we have submitted the screenshot of that email, but my lord has directed to bring the original. If your lordship kindly give me short pass over, I shall protest.
Yes, that is not a difficulty. I'm asking you something else. What is their contention? Their contention is that they were not served with the complete order.
Complete order in original.
Which prevented them from filing the appeal. Is it correct?
Our is that our contention is that subsequently when they bring to our notice that they have not received the preamble, we have served entire copy of the petition through email to the authorized representative to the advocate's email ID, my lord. Yesterday, earlier occasion we have submitted before your lordship.
My lord, earlier occasion my senior also submitted that they, as per provision, they cannot serve the original through mail, because there is a mandatory provision to serve the original by post.
Very well, that is their contention.
Yes. No, that is the
I accept the fact that they will have served the complete copy by mail.
My lord told them to serve a copy of original. We can prefer the appeal within 1 month.
Yes. What is the provision for service?
37C of the Central Excise Act.
Now, among Central Excise Act. I'll dispose it of. This is pending for at least on 2 occasions. This was taken up.
Yes.
6th and on 13th. So yes, I'll dispose it of today. বই আনতে বললাম আসছে না কেন? 2 দিন লাগছে বই আসতে। Yes.
Yes, my lord. 37.
Place it. You kindly place it.
Yes, my lord. Any decision or order passed or any summons or notices issued under this act or the rules made thereunder shall be served by tendering the decision, order, summons or notice, or sending it by registered post with acknowledgement due, or by speed post with proof of delivery, or by courier approved by the Central Board of Excise and Customs constituted under the Central Board of Revenue to the person for whom it is intended or his authorized agent, if any. If the decision or order, summons or notice cannot be served in the manner prescribed in clause A, by affixing a copy thereof to some conspicuous part of the factory or warehouse or the place of business or usual place of residence of the person for whom such decision, order, summons, notice, as the case may be, is intended. If the decision, order, summons or notice cannot
so
be
there is no scope for service.
Yes, service.
There is no scope
under
for
under the
but the thing is that nowadays, my lord, electronic
correct.
mode of service is, my lord.
No, so therefore, since he gets a benefit here, what I will do is, Mr. Maiti, I will treat that service has been effected on him today.
Yes, ma'am.
I'll not accept his challenge. I'll treat that it has been served on him today. There may be some confusion, although I'll record your submission that it has been served on them via mail. So, whatever in law, whatever rights they have, they will exhaust.
Yes.
They cannot be non-suited for this purpose. The short point involved in the present application is whether the petitioner has been served with the copy of the order in original. Copy of the order in original in a proceedings under section 73. Where is that?
My lord.
In a 73?
Finance.
And actually, in a proceedings under section 73 of the Finance Act 1994, hereinafter referred to the said act, full stop. It is the petitioner's case that although the petitioner was served, it is the petitioner's case that the petitioner was served with a show cause cum demand notice dated 25th of April 2019. In respect of the financial year, what is the period? 2014-15. In terms of section 73 within bracket 1 of the said act. First up, the petitioner had duly responded to the same, and ultimately the aforesaid culminated in an order. Ultimately, the same culminated. Hey, which is the, just a minute. Kindly come to page 40. What is this? Which is the show cause?
40, my lord.
Where is the show cause? Show cause page 30 or 40?
30, my lord.
What is 40?
Suppose the human notice 30, my lord.
30, my lord.
What is 40?
For
opportunity of personal
personal hearing, my lord. Personal.
আচ্ছা, তাহলে কি বলি? And after affording the petitioner with an opportunity of hearing, the said proceedings was disposed of by passing an order in original. The problem arose, although the said order was purported to be served on the petitioner via an email communication dated 6th of August 2022, although the said order in original dated
17/6/2020.
17/6. Where I got it?
My lord, page number 49.
Just a minute. Dated 17th of June. No. 27. 49 is 27 June. What?
No, my lord, this is
17. Yes. Yes. Was purported to be served on the petitioner via an email communication dated 6th of August 2022. The petitioner claims that a truncated scanned copy of the said order was only served on the petitioner, and the entirety of such order was not served.
photograph.
Scanned copy.
Photo. Kindly see each page photo.
As a photocopy. Scan, photocopy. Photocopy.
Photograph of each copy.
Although by communication in writing dated 23rd August 2022 and 28th August 2022, the petitioner had called upon the respondents to make over the copy of the order in original. Such letter was apparently not responded to. On the contrary, a demand notice dated. On the contrary, a recovery proceedings was initiated on 8th March. Recovery proceedings was initiated by what is this document? Page 52.
Well, this is the recovery letter. Subject
No,
recovery.
by the Superintendent of Central Tax. Range 5, Sakral Division, Howrah Commissionerate, by issuing the letter dated 8th of March 2024. So, Mr. Chakraborty, learned advocate representing the petitioner, has placed before this court the provisions of section 37 within bracket C of the said act, and has attempted to in support of his contention that an order in original ought to be ought to have been served on the petitioner in the manner provided therein. First up, since the service of the petitioner, since the complete order has not been served, in any event, since the complete order has not been served, the petitioner has been prevented from availing its statutory remedy. And in the facts as noted here in above, no recovery proceedings can be initiated. That is all. Mr. Maiti, learned advocate, by producing the records of this case, has attempted to justify that subsequently, by an email communication dated
29/8,
Yes.
29/8, we have forwarded.
No,
Actually, you have signed handed over by an email communication dated 29.
2022.
December. December 2020.
December 22nd December 2020.
20th December 2023.
20th December 2023. The aforesaid order has been served. Full stop. He has, however, been candid by placing before this court the envelope containing. He has been candid by placing before this court the copy of the envelope. Now, he has, however, acknowledged the fact, candid. He has, however, acknowledged the fact that the envelope containing the said letter, it's an order in original, has been returned to the to the respondents with the had been returned to the has been returned to the
address to the
respondents with the endorsement, postal endorsement within inverted quote in italics, insufficient address. Postal. The petitioner postal. The petitioner submits that now. So in reply, Mr. Chakraborty, by placing before this court the ওখানে আছে না ওই envelope হ্যাঁ, let a copy of the aforesaid envelope be retained with the record ওপরে তারপরে in reply Mr. Chakraborty, learned advocate representing the petitioner, আগে তো বলা আছে Mr. Chakraborty, in reply Mr. Chakraborty, by referring to the communication issued by the recovery officer dated 8th of March 2024, submits that the said letter was also forwarded to the petitioner by post and was received in the same address and was received at the address of the petitioner, and as such there was no reason for the previous letter to be returned with the endorsement insufficient as the address, full stop, since the respondents have failed to demonstrate service of order in the manner provided under section 37C of the said act. The email communication should not be accepted by this court as service of such order. That is all. Anything else you want to add? Or the learned advocates appearing for the respective parties and consider the materials on record. Full stop. Admittedly, in this case, the petitioner participated in the proceedings. Yes, I'm sorry. Yes, I'm sorry. Heard. তারপরে আরেকটা লাইন ও রিপ্লাই এর আগে ওই যে উনি যে মিস্টার মাইতি বলেছেন মিস্টার সিনহা লার্নেড অ্যাডভোকেট মিস্টার সিনহা লার্নেড অ্যাডভোকেট heard Mr. Sinha, learned advocate representing the respondent number 1. ওইখানটা তারপরে in reply, having heard the learned advocates appearing for the respective parties and having considered the materials on record, I notice that the only issue that falls for consideration is now. Heard the learned advocates appearing for the respective parties, considered the materials on record, full stop. Admittedly, in this case, the petitioner had participated in the proceedings under section 73 of the said act, full stop. The original show cause notice was served on the petitioner at his registered address, full stop. As such, I do not as such registered address, full stop. Although Mr. Maiti, learned advocate, had claimed that the envelope containing the original order in original could not be served on the petitioner by reasons of insufficient address, I do not find, I am of the view that the postal endorsement made on the said letter does not further the case of the respondents that the order in original had been served with the all the system. Although Mr. Mighty submits that in addition to the postal service, further attempts had been made to effect service through email communication, I am of the view such communication does not have the sanction. No, I am of the view such communication do not constitute service of the order in original, and does not constitute service of the order in original, does not constitute valid service, does not constitute valid service of the order in original by reasons of the provisions contained in section 37C of the said act. Full stop. To more fully appreciate the same, section 37C of the said act is extracted herein below. Full stop. Having regard to the aforesaid, I am of the view. No, full stop. Having regard to the aforesaid and taking into consideration that the petitioner had not been served with the copy of the order, though in course of hearing this day, a copy of the original order in original has been having been made over to the petitioner, to the learned advocate for the petitioner, the service of the order in your date of service of the order in the this day shall be construed to be the service of the order in original on the petitioner. Full stop. Service of the order in original. And further taking into consideration the fact that the order in original has been served by Mr. Mighty learned advocate to the learned advocate for the petitioner in court today, I am of the view that the aforesaid should be construed as valid service of the order in original. Full stop. Order in original. Full stop. Full stop. Full stop. In view thereof, full stop. The petitioner shall be at liberty to. Yeah, full stop. What is the time period for compliance?
1 month.
No, before which recovery cannot be issued, is there any embargo or immediately? At this stage, no, it's been served today, so why delay? No delay. At this stage, Mr. Chakraborty, learned advocate, submits that none dorkar nei.
They will take steps in accordance with.
Yes. Having in view thereof, since nothing in view thereof, the petitioner shall be at liberty to take steps in accordance with law. Na, as a sequel to the aforesaid, the recovery notice dated 8th of March 2024 stands set aside. Full stop. The aforesaid order shall, however, not prevent the respondents from initiating proceedings for recovery upon expiry of the statutory period as provided for in the said act. Full stop. With the above observation directions, the writ application stands disposed of. They shall no more. Call the next matter.
17.
ঠিক আছে। Yes, ASM-10.
It was not. It was not issued, my lord. When a proceeding has been initiated, when I've taken it to
Scrutiny.
under section 61, then I'm bound to follow rule 99. But following that instruction of 2022 issued by the CBIC as well as Rule 99, ASM-10 ought to have been issued. It was not issued, my lord. But
The-
subsequently culminated into adjudication proceeding and we started adjudication without issuance of ASM-10.
So the petitioner has challenged in the present, by way of the present writ application, the petitioner has challenged the order dated 29th of December 2023. Where is that order? Where is that order?
Page 24. Adjudication of order. Taking section at page 26. After the signature digital signature. Or 12.29.
Issued under section 73 within 9 of the West Bengal Goods and Services Tax Act 2017 and Central Goods and Services Tax Act 2017, read with section 20 of the IGST Act 2017, opore, hereinafter referred to the said act, dated. Date is not in the column, not in the column, no.
Not the column because the that at page 27 is given in the portal. There also it is 29 December. If you should kindly see page 27 also.
On 29 December, dated 29 December 2023, in respect of the period, for the period 1st July 2017 till 31st of March 2018. According to the petitioner, who is engaged in the business of providing goods transport agency service and is duly registered with the said act, registered under the said act, is scrutiny is scrutinized. The returns filed by the petitioner was scrutinized by the proper officer in terms of section 61 of the said act. Unfortunately, the proper officer did not inform the petitioner of the discrepancies by making the petition by making available the form ASMT-10
From
form number.
GST,
No,
GST ASM-10.
form GST ASMT-10 for the petitioner to take steps. First of all, unfortunately, when the show cause notice was issued, the same also, when the show cause notice dated, where is the show cause notice?
Page number 91. Dated
When the show cause notice dated, there is an annexure.
That to show cause,
29th September.
that to show cause intimation before show cause was also issued,
No.
which is at page 15.
None of the cases is,
No, ASM-10 was not issued. We started from intimation 73.5, then 73.1, then 73.9.
কি বলছে? Unfortunately, when an intimation of liability no, this is after the show cause.
No, pre-show cause, pre-show cause.
This is pre-show cause. In terms of
Uh,
section 73.
Unfortunately, when the intimation of liability was given to the petitioner, by issuance of a notice dated 26th of September 2023,
Hmm.
or when the show cause notice dated 26 September 2023 was issued, the petitioner was not favored with the form ASMT10 for the petitioner to be made aware with regard to the discrepancies. Mr.
So cause notice is 29. So cause notice is 29 September.
On the top,
The
Oh, four
intimation,
pages, 29
pre-show is 26 and it is 29.
29 September. Mr. Mojumdar, learned advocate, by drawing attention of this court to the show cause notice, submits that when a scrutiny is conducted, drawing attention to the show cause notice, and by referring to section 61 and rule
99.
99 of the West Bengal Goods and Service Tax rules, same rule.
And perimeter. Yes, to
দুটো ই দেবে 1999 শুধু 99
Rule 99, sub rule 1, my lord. To be precise.
submits that when where any return is furnished by a registered person is selected for scrutiny, the proper officer submits that it is the obligation of the proper officer to identify the discrepancies and notify the petitioner in form GST ASM-10 full stop. In the present case, since the petitioner had not been notified with the aforesaid discrepancies by issuance of form GST ASM-10, the petitioner could not appropriately respond to the show cause, and the final order and the adjudication order issued under section 73 within bracket 9 of the said act stands vitiated on such ground. Full stop. Mr. Siddiqui, learned advocate, representing the department representing the respondents, acknowledges the fact that the petitioner ought to have been served with a copy of the form
GST assembly.
GST ASMT10 for the petitioner for ASMT10. Full stop. Having taken note of the aforesaid and considering the fact, having heard the learning advocates appearing for the respective parties, paragraph, having considered the materials on record, including the provisions of section 61 and rule 99, section 61 of the said act and rule 99 of the said rules, since the rule 99 of the said rules, I am of the view, since the petitioner was not served, since the petitioner was not identified, since I am of the view that it was the obligation of the proper officer before passing any order in terms of rule 99 read with section 61 of the said act to make available to the petitioner form GST ASM-10 and to identifying therein the discrepancies noticed by him while scrutinizing the returns. Since the same had not been made available to the petitioner, the petitioner could not appropriately respond to the show cause. Full stop. The aforesaid order thus stands vitiated on such ground. Thus stands vitiated on the ground of violation of the principles of natural justice. Full stop. Having regard to the aforesaid, I set aside the final order. I set aside the adjudication order under section 73(9) of the said act dated
December.
29th of December 2023, and direct the proper officer to forthwith within 2 weeks from the date of communication of this order to make available form GST ASM-10 for the petitioner to respond to the show cause and to provide appropriate opportunity to the petitioner to respond to the show cause. Full stop. The entire proceedings, however,
Respond to that.
show cause.
It is not a GST ASM-10 is not a show.
No, previous show cause is there. Show cause has to be
He has to respond to that.
respond to the show cause dated 26
29.
September 2020, 29 6 September.
26 September is the intimation before show cause. And the show cause is 29 September 2023.
26 September 2023. Full stop.
For corresponding sentence.
If the petitioner responds to the said show cause or fails to respond to the said show cause upon receipt of the copy of the form GST ASM-10 within 2 weeks from the date of service of such form on the petitioner, the proper officer, upon giving an opportunity of hearing to the petitioner, shall dispose of the said proceedings in accordance with law, preferably within a period of 2 weeks therefrom. 4 weeks therefrom. Therefrom.
4 weeks there.
4 weeks therefrom.
2 plus 4.
Yes. With the observation, yes.
Subject to correction, my lord, the 2017-18, it is period involved is 2017-18, which is time barred, my lord. Which is
This point cannot be raised now because participated in the adjudication procedure.
no, adjudication proceeding was initiated based on 61, and that is vitiated.
But my lordship may kindly
It is my
appreciate intimation before show cause, he participated in it. He participated in the show cause. Thereafter, adjudication order was passed. He comes up before your lordship. That could not
Have you
been
taken that point?
No, my lord.
Have you taken that point in the writ petition
Yes. Point number 5, paragraph number 5.
after vacation?
But
My
the
lord-
officer will take into consideration this notification.
No.
That will be taken into consideration.
How can it be freshly initiated?
While disposing of the said proceedings,
Now,
The-
point number,
the-
paragraph 5 is not that.
the proper officer
That point has not.
shall take note of the the officer shall dispose of the said proceedings by taking note of the notification dated 12th April 2023 issued by the Finance Department, Government of West Bengal. So if they decided, they decided.
We will take.
You did not raise this point earlier, sir.
Not written in the writ petition, paragraph.
No.
Paragraph 5.
Yesterday also,
The paragraph 5, my
on
lord.
6th of May, or yesterday when it was heard, you did not raise this point, sir. With the, I have just kept it open. So if you are entitled to, having regard to this, let a copy of the aforesaid notification dated 12th April 2023 as made over in court today by the petitioner's learned advocate be taken on record. Full stop. Full stop. With the observation directions, the writ application stands dismissed since I have not called for affidavits. No. Let us say I can admit it.
Oblige.
33.
Yes.
My lord, on the last occasion, your lordship was pleased to reaction.
Yes.
সাইডে বসে বসে কোনো অসুবিধা নেই
Yes.
Yes, my lord. I have my instructions, my lord. Something very interesting has happened here. Now, my lord, the writ petitioner, when he files his return, my lord, in the return, he has indicated that he has received the sum of rupees 1 crore, not by way of an advance, but by way of consideration, my lord, of immovable property.
File affidavits in that case.
Yes, has to be. There's
My
no
lord.
scope for interim order. And my lord, in the
I remember your matter, sir.
and my lord, in the,
Affidavits.
I just want
I cannot dispose it of.
and my lord, before the magistrate, before the magistrate,
I can do one thing. I can permit them to file a report, short report.
yes my
in
lord
the form of an affidavit.
So same thing,
Yes.
makes no difference.
your lordship
I will hear it on the same position.
Yes,
my lord
definitely.
That I can do.
my lord kindly my lord
Considering the nature of grievance, I am of the view that an affidavit in opposition respondent should be granted liberty. Considering the nature of grievance of the petitioner and the issues involved, I am of the view that the respondent should be granted liberty to file affidavit in opposition, to use an affidavit in opposition. Full stop. In view thereof, let affidavit in opposition to the present application be filed within a week after the summer vacation, one sufficient time.
Yes.
Reply, if any, there to be filed within a week thereafter. Postal list this matter in the week no, within 2 weeks, 1 week, 2 week, 1 week. List this matter in the monthly list of July 2023, 2024 under the same heading.
Great. My lord, may I just humbly state one?
No, no, nothing. But so many matters are there. What will you say? Your matter is over. Can I dispose of your matter now?
No.
Then that is. In fact, from next week, I'll try to hear the urgent matters. Anyone wants to mention the matter tomorrow, you can mention it.
Yes.
I'll provide for in the list.
Well, my refund has been withheld due to this.
It's all right. That's not what can be done. It is with them. You'll get back with interest if you can succeed. What more? You'll not even get bank's rate of interest. Bank will not give you such interest. Let's call the list.
Agenda 43.
Yes. No.
Lordship, at the time of last hearing, Lordship had cited Oryx Fisheries case, Lordship. Lordship, in my humble submission, Oryx Fisheries case was related to cancellation of registration.
What is the challenge? Just remind me.
Oh, Lordship, I have challenged the assessment order which has been passed under section 144B of the Income Tax Act in violation of the standard operating procedure which has been laid down under section 144B itself, Lordship. The act itself lays down that the assessment shall be completed as per the procedure which is prescribed in this section. And a standard operating procedure has been laid down by the Principal Commissioner of Income Tax, which has not been followed.
File an appeal.
Lordship, violation of standard operating procedure leads to
Violation of standard
Lordship,
operating
I
procedure
rely on,
and violation of natural justice are the same.
yes, Lordship, I
Same.
rely on two decisions.
Same.
Lordship, violation of
Yes,
SOP.
decision. Yes.
Yes,
show me.
Lordship. This honorable court, Lordship,
Yes.
in the case of Indu Goenka, in a similar circumstance, where the standard operating procedure was violated, Lordship, the assessment order was quashed, Lordship.
Yes.
Lordship, section 144B, if I may refer to that
No.
section,
Come to the order. Come to the order, sir.
Lordship,
Show me from the order what has been violated.
Lordship, my written submission, which was filed on 7th March, has not even been referred in the assessment order, Lordship. And that's it directly against the standard operating procedure.
So that is the reason.
That is one of the reasons.
Very.
Because standard operating procedure has been violated. I will show, Lordship, from the standard operating procedure that
Written note not referred.
before passing the assessment order,
Written note not referred.
not
What was there in the written note?
I had relied upon 3 decisions, Lordship. He has not even dealt with those decisions.
What are the decisions? Tell me, show me.
Yes. Lordship, my written submission is from page number 236
Yes.
onwards. Yes, Lordship, in volume number 1,
Yes.
Lordship will find in volume number 1, 236 onwards. I had
Sir, is it a point that cannot be raised in appeal?
no,
No,
Lordship,
are you trying to suggest?
in my humble
No,
submission,
are you trying to, I mean, I don't know from you, sir. From
sir, Lordship, in my humble
Tell
submission,
me something, sir. Is it a point which cannot be raised in appeal?
it can be raised in appeal, Lordship, every point. But Lordship, the
No, not every point.
no question before
Like,
your
for
Lordship
instance,
is,
you did not give any opposition.
no, Lordship, my humble
What
submission,
point you will raise?
Lordship, my humble submission is when a procedure has been prescribed in the law itself, Lordship,
Yes.
then if the procedure has not been followed, then that is a violation of natural justice.
Complete your proceedings and come back. Let the appellate authority consider this.
But Lordship, going to the appellate authority is not a,
This, sir, in this judgment which you showed me,
Yeah.
nothing was considered. It was zero.
in my case also,
That is
Lordship.
why I show the order.
Yes, Lordship.
And no detailed inquiry, sir. I am not sitting in as an appellate authority, sir.
Lordship, I am not on any merits, Lordship.
Show me, sir.
Only on 2 points, Lordship.
Show me.
Yes. Lordship, the assessment order. Lordship, the assessment order starts at page number 454.
Yes.
Page number 454, Lordship. The assessing officer gives the details of the queries which were raised. First, he gives those details,
Yes.
and then in page in para number 4.2.2, Lordship, on page number 459. He gives the synopsis of the submissions of the
you.
SSC, where he does not refer to the submission which I made on 7th of March. That is not dealt with at all, Lordship. Even though it was submitted in pursuance of virtual hearing that was granted to me, and at the time of submitting my submissions on 7th March, I have clearly written that during the course of virtual hearing, whatever you have asked me, I am giving by
Sir,
way of this.
for instance, you ask for 5 prayers. 5 prayers are made in a plaint. 3 are granted. The court is silent about the 2. What happens, sir? Is it violation of the procedures?
In my humble
Court is required to return findings on all issues.
in my humble
You have to go before the appeal, sir.
my humble submission, Lordship, the procedure which has been prescribed in a faceless assessment. Lordship, only one point I want to place before you, Lordship.
Thereafter. 4.2 synopsis all sufficient.
4.2.2, he gives the synopsis of the replies which has all the submissions. Thereafter, Lordship, in para 4.2.3,
If I make a finding, sir, please understand. Please understand.
I'm-
I have to deal with your matter. Whatever you argue, please understand what I'm saying. I will go into the facts and I will go on recording. And I have a habit of recording whatever you submit. And I will record and I will answer. Now that might prejudice you if I am not with you ultimately. You have to take your chance, because at that stage, I will not hold back. I'm making it very clear. You make up your mind on this. I will consider your whatever submissions you make and deal with them. Now you are practically, by this process, you are arguing on the merits, touching the merits. It has to. Sorry, there cannot be a matter where without touching the merits you can argue, unless you show that absolutely nothing is there. Okay. So you will be touching the merits and I will be responding. My response here, even if ultimately if I am not with you, I'm not saying that today I'm not with you. Ultimately, if I'm not with you, that might prejudice your interest. So be conscious of that and then proceed.
I will limit my arguments only, Lordship.
No, not the question of limiting, because I will require to be considering the facts of this case, since there appears to be a reasoned order to deal with your contentions. I will be required to touch the merits of the case. Now, once I do that, I will not hold myself back for that purpose. I'm making it very clear to you. Proceed.
Lordship, in para 4.2.4
Yes.
on page number 469, he says variation proposed on the basis of inference drawn. And Lordship, that he refers to that. And thereafter, Lordship, then synopsis of my reply to the SCN is given on para 4.3 in page 470. Whatever reply I submitted.
Very well, I'll fix this matter. I'll record this matter is required to be heard. I'll fix this matter after the vacation, Mr. Rai, and I will decide this matter on merits. On merits. And if I ultimately find I'm with him, I will allow it. But if I'm not with him on that, I will make certain observations. Since he's touching, now he's arguing on merits.
No, Lordship, Lordship.
Absolutely.
Yes, before he proceeds, my lord, your lordship will hear me, my lord, on the maintainability aspect of the writ petition. My lord, I will-
Absolutely. Everything is kept open.
Yes, yes.
Everything
Because,
is
my lord, in
kept
my
open.
respectful submission, it is not entertainable.
The
at all.
petitioner seeks to challenge the assessment order on the ground that standard operating procedure has not been followed by the adjudicating authority. First up. Mr. Rai, learned advocate representing the respondents, submits that there is an appellate authority. The submits that the order passed by the adjudication officer is appealable, and as such, this court, in exercise of its extraordinary jurisdiction, ought not to entertain the present writ application. First up, having regard to the aforesaid and taking note of the submissions of the parties, I fix this matter for consideration on the point of maintainability. First up, list this matter in the monthly list of June 2025.
Grateful, Lordship.
ওটাকে দিয়ে দিন। Hearing. It will appear under the heading hearing. But there is no stay. I am not.
But I am for the petitioner. Challenging an order of assessment which is otherwise appealable under the Income Tax Act on a single ground. I will show only a single sentence, a single
Yes.
point. If your lordship is not with me, then I will have the appellate remedy. Single ground. Kindly
Because you
come.
understand this, Mr. Chakraborty.
Only I have
You
to show.
insist, because you insist I have to deal. And in the process,
I may be prejudiced.
I don't know. I put you on that. I'm very clear, because
But
at the end of the day, a clean slate is much better than suffering some sort of an order and going. And even if we do not record that this should not be considered, should not be guided, but still then an observation
it may
made
be a
by
wrong
the head.
find. But I have to demonstrate.
Show me if you have a right, I'll show.
Correct. Only one thing I will show. Page 180. 180
Yes.
include order. Mr. Rai will also consider that whether my point has some merit or not. My lord will kindly take paragraph Roman 2. My lord will kindly mark the office has received information in this case that has been identified and flagged by the Directorate of Income Tax System, CBDT, that is Central Board of Direct Taxes, in accordance with the risk management strategy formulated the board as per provision of clause I of explanation 1 to section 148 of the Income Tax Act. The next sentence I am harping. Information and materials were received from the Office of DDIT Investigation Unit 2 within bracket 1, Kolkata. In connection with the inquiry,
Which?
I am reading from Roman 2,
180.
page 180,
Yes.
Roman 2. Kindly see the sentence information. Information and materials were received from the Office of DDIT Investigation Unit 2-1, Kolkata. in connection with the inquiry in the case of Virendra Kanyani and others. That Messrs. Sim Singhal, that is the petitioner over here, bearing such and such made bogus purchase. And I stop here. So the entire basis of the case against me, that is Sim Singhal,
From third party.
from a third party. So I have at least a right to know what is that information, what is that material. Till that I have not been given.
Where have you asked?
During the process, I asked for where is the information. I produced all my documents. The interesting thing, I must
Yesterday, Mr. Sannal moved a matter. I refused his relief. That was a better case than yours. There, the case was, he was third party issue was there. He was seeking liberty to cross-examine.
Cross-examination is different, madam. There are lots of judgments of this Honorable High Court in the writ petition.
And the Honorable Supreme Court judgment, Mr. Chakraborty, you should be aware that on this ground, the entire order of the assessment should not go.
Well, the Honorable Division Bench of our Honorable High Court, last order, madam, so if I can remember correctly, has passed the order by remanding the matter, saying that unless you give cross-examination, you cannot rely on it.
Yes, in that particular case, that judgment was also relied. But there, the case was different. The department allowed the first. The judgment says the department allowed that. Now,
Nobody appeared.
due to technical glitches, nothing could be possible. No hearing took place. So he asked for
Another
issuance of a second one. It was refused.
No.
That was the case.
Maybe that judgment placed before your lordship. Then another judgment, the last judgment, and that judgment has been considered by.
Question is, how are you prejudiced?
I'm saying how I am prejudiced.
That is the only issue.
One sentence. I will say only one sentence. This entire case of bogus purchase against me, with respect to 4 parties. Interestingly, the information they are relying on of GSTI, that is Directorate General of Goods and Service Tax Intelligence, they proceeded against me with respect to 1 party, not for 4. They investigated first. They found 3 are okay, no bogus purchase. With respect to 1, they let's suppose I'm giving. Their information first was for 4 parties. They on investigation found 3 are correct. But income tax on that information proceeded against me on 4 party. This is how I am prejudiced. That cannot be. He took a figure of 1 crore. If 3 persons are cut down, it will come down to 1 lakh. That is how I am prejudiced. He is saying my purchase is bogus. So that amount which I showed as my expense towards purchase, he added it to my income. Wait, I know that. Now, if this is the position, that material is required to be disclosed. Their material is on 1 party and he is proceeding on 4 parties.
Then any report.
My lord, we have disclosed the material. My lord, my learned friend's case, my lord, as it appears from the writ petition, my lord, is based on, my lord, the so cause notices which were sent to him. If your lordship kindly takes the page number, my lord, 148 AB notices. My lord,
That those days have gone. I'm not on those.
It is on those only, because that is your averment in the writ petition. Now, my lord, he says,
where is that?
Kindly have a look, my lord, at page 119. This is his case in the writ petition. Page 119. This is, my lord, the notice under 148A B, asking him to show cause, and the information is supposed to be supplied to him. Now, my lord, if your lordship turns over the page, he takes advantage of this. Page 120. And the averment in the writ petition is that nothing was supplied.
Kindly see, this is what supplied.
Yes, I'm proceeding further. My lord,
120.
Yes. 120, my lord, information available with the department in your case is enclosed herewith. My lord,
where is that?
Enclosure could not be then sent. My lord, by a subsequent email of immediately 2 days thereafter. My lord, this is 21st of March 2022. My lord, on 22nd of March 2022. This fact has not even been, my lord, whispered in the writ petition. My lord, this is the screenshot of the email that was sent. And my lord, I'm also submitting, my lord, the email along with the annexure.
Supply him a copy.
Yes, I'm supplying him a copy.
Where is the
And my
attachment?
lord, My lord, that is the attachment.
Oh, yes, on the top, I've seen that.
Yes, and my lord, kindly see, my lord, the information supplied.
মানে এই attachment
Of course.
এটা?
দিচ্ছি, আরো দিচ্ছি।
Attachment
And
is
look-
there, Mr. Jokro.
Yes, and my lord, there is no reply to
Attachment
this.
is there.
This is
There is no, not only this,
Have-
there are many. I'm
No.
giving one after another.
Anyway, but the attachment is there. Question is, very well. I will go through this, Mr. Chakraborty. The attachment is there.
let me go through.
My lord,
I
now
was-
this, let me go through, my lord. After this, my lord, it will be a case on merits then.
Yes.
He did not
This
deal
is
with
the
this.
same thing what I was saying.
This
My lord, we can
very
listen.
well, it is the same thing, my lord. He has to deal with it. My lord, why did he choose not to deal with it in reply? He was given an opportunity. My lord, your lordship will kindly consider this. When your lordship, my lord, is testing these types of order in your lordships, my lord,
These are third parties.
yes,
Kindly see.
all information provided. My lord, it is on this basis that I seek to reopen. My lord, he does not respond to that. My lord, I reopen. I pass an order under 148 AD. He does not object to the 148 AD order. No challenge is thrown, my lord. 148 AD order, my lord, attains finality.
148 AB response is there.
He does not respond
Yes,
to
yes,
it.
I responded.
No, where? 148 AB, there is no response. My lord, kindly have a look at 148 AD order now. That
No,
is
no, first
recorded.
of all, show me the 148 AB notice.
Yes, that I showed.
That
my
is,
lord,
this is page 119.
Yes.
119.
Now,
Slowly,
my lord,
slowly.
page 121 is the
Wait,
148.
wait. Then is the communication. Where is the communication? Email communication? This one.
This is the email.
No, which
communication.
one? This one. This one. Date.
Date is next date.
Hmm.
23rd March.
Next date, 21st March, my lord, was the,
Where is that communication?
this is the communication.
My lord,
23rd March. My lord, 23rd March. My lord, this email, which was forwarded to me, I have
That's 15th of May. Oh, no, that's forwarded to you. Forwarded to you.
original message, your lordship will find, my lord.
Where is that? Where is it?
Original
I get you.
message.
Very well. Very well.
Original message. That is the original message
Very
which has been forwarded to me.
Thereafter,
Thereafter, my lord, page 121.
yes.
148 AD order passed.
Without, wait. Let me go through this one.
Yes, please.
my lord is looking into 121.
This is GST department also shared their incident report.
First sentence and then the second paragraph, first sentence.
Yes, sir.
Until today, my lord, my only submission is this has not been provided to me. This GST department information, what they are
Where
working.
have you asked for this?
My lord,
Where have you asked for this?
Correct.
You did not respond to the 148 AB notice.
I responded to everything.
No.
I
Show me that.
148 AB notice, you have not responded.
Show me that.
And Lord, kindly keep this
Wait,
in mind, my lord. These orders were passed in 2022. This 148 AD order, my lord,
I'm not
is dated
challenging that.
2022. Now, my lord, therefore, he challenges the assessment order. I have some submissions on that. Assessment order is also time barred if an appeal is preferred today. Whether a lordship will entertain, my lord, a challenge to an order, my lord, which in course of its original, my lord, proceedings has died an natural
Otherwise,
death.
assessment order is done time barred.
Yes.
No.
Yes, today it is. My lord, your lordship will kindly see on the day when the writ was preferred and when
When was the
order
writ filed?
passed.
Filed. I may have
Yes.
taken up later.
Yes.
I'll first date. I'll tell you that. I'll tell you.
Page
You tell me the other dates. It is on 23rd April.
23rd April. Now, my lord, kindly see the date of the order, page 180.
20th March.
20th March.
20th March.
So 20th of April, my lord, it will expire. 30 days.
No, not 30 days.
Yes.
This is an assessment order. The appeal lies before the appellate commissioner. There I have a period of 3 months.
3 months. No.
1 month. My lord, I stand corrected. 1 month. Mr.
1 month,
Einstein.
then 30 days. Therefore, my lord, today the challenge here also, my lord, your lordship remembers, my lord, at least 3 judgments of Supreme Court. Well, my lord, very well settled, my lord, that if of E, my lord, if
Judgment is not necessary. For that judgment is
Yes,
not
yes,
necessary.
that is why, my lord.
What
it
that
is true.
judgment is not required.
Very well settled.
If
my
I
lord.
am delayed, I am delayed.
You see, factually,
But it
it
is
is
condonable.
very strong case. Very strong
Yes,
case.
yes, my lord, because your lordship, my lord, in exercise if 226, everything is maintainable.
But,
Question is entertainability.
but
20th March.
unless a very strong and exceptional case is shown,
20 March and 23rd April. এক মাসের বেশি। But this is otherwise condonable. 19th April session. The otherwise condonable.
take back, take back. You want me to dismiss it? Or you want to take back?
With liberty,
I will not grant any liberty. Dismiss it, that I'll complicate the issues.
no.
You want to take back, you take back.
If I,
I'll record very well.
my lord will kindly record. But my lord will kindly consider. I am not on merit. I am not on merit.
I've record your submission.
Only that
I've-
GST.
Mr. Chakraborty, I've never. Have you found me not recording the submissions? If you have not argued something, that will not be there. But if you have argued, that will be there.
That's why at the very beginning I said I will argue only one point.
The present writ application has been
That
filed
is not
literally
satisfied.
challenging the assessment order passed under section. Where is that as 180?
180.
Passed under section.
এই আমার লাগবে তো না
147 read with section 144 of the Income Tax Act 1961. Mr. Chakraborty, learned advocate, by drawing attention of this court to the assessment order submits that although the aforesaid assessment was conducted on the basis of information and materials received from the office of the DDIT, investigation, U2 within bracket 1 Kolkata. এখানটা আছে 180 দেখে নিও।
and my lord GST department next page.
That is it. Recorded. It is
Next page.
the information is as under.
Kindly see the next page again. That is DDIT. Two sources. One is DDIT, one is GST.
As also
The first
certain as also the incident report shared by the GST department.
at
The
the top.
aforesaid documents had not been made over to the petitioner, which has the effect of vitiating the aforesaid order.
And although these 5 GST proceeded with respect to 1,
It is further submitted that although out of the 5 entities from whom information was gathered, out of the 5 entities
alleged to be
At-
fake.
appearing at page number 181 of the writ application, who are alleged as fake entities, the GST authorities had proceeded against only one of them. Postal. However, in the present case, all the 4 entities, all the 5 entities have been treated to be fake entities, and the entire
Purchase
entire purchase,
has been added back to the income.
you purchased it.
I purchased. So that was my expense.
Yes, yes.
So they have
And the entire purchase made by the petitioner from the aforesaid 5 entities have been added back to the petitioner's income. Postal. Anything else, sir? You want to add?
so my only prayer was for this
It is submitted. It's his Mr. Only copy you want.
only that information, because I can show that
The order we
information
are easier.
contrary. Otherwise, my lord, why I was before your lordship?
In the facts noted here in above, it is submitted that the aforesaid order
Incurable
cannot be
defect
sustained
cannot be
without.
cured in appeal.
In the facts noted here in above, it is submitted that the aforesaid order cannot be sustained since the petitioner had been denied the opportunity to appropriately respond. submits that he would sustain, since the petitioner has been denied the opportunity to appreciate the purport of the inquiries and thereby appropriately respond to the same. Mr. Rai, learned advocate, representing the
Income tax.
respondents, all the respondents, only representing the department, at the very outset submits that the order impugned in the present writ application is an appealable order. Because of the said order has been passed on
20th March.
20th March.
20 March.
20th of March 2024. Full stop. The present writ application has been filed on 23rd of April 2024. Full stop. As such, the ordinary period for maintaining the appeal has also expired. In such circumstances, this court ought not to entertain the present writ application. Full stop. By drawing attention of this court to the notice are issued under section 148 capital A within bracket B small b of the said act dated 21st of March 2022 for the assessment year 2018-19 appearing at page number 119 of the writ application, it is submitted that the petitioner was duly notified with regard to the circumstances under which the said proceedings had been initiated. Unfortunately, the information based on which the said proceedings had been initiated was not made available to the petitioner along with the said notice dated 21st of March 2022. In such circumstances, such defect having come to light, the department by an email communication dated 23rd March 2022, within 2 days from the date of service of such notice, caused the information to be made available to the petitioner.
And my submission is, it is not the information.
Then you cannot dispute it today.
My lord, we can record.
Mr. Rai, learned advocate, in support of the aforesaid contention, Mr. Rai has placed before this court a forwarded email communication, a printout of the original email communication dated 23rd March 2022, which had been forwarded to him, enclosing therewith all information based on which such proceedings had been initiated. Copies of this is submission, sir. I will not record.
I am not
You're
saying.
shaking your head. That is the reason.
My mistake. I tender. I should not have.
The relevant documents as made over in court today by Mr. Rai are retained with the record. Retained with the record. By placing before this court, by drawing attention of this court to the order under section 148 capital A within bracket D of the said act, Mr. Rai submits that no new information has been disclosed in the assessment order. Full stop. The aforesaid order under section 148 capital A D of the said act would demonstrate that the circumstances leading to initiation of proceedings under the said provision, not only the information received from the DDIT investigation U2 within bracket 1 Kolkata was taken into consideration, but the GST department memo, GST department incident report was also taken into consideration as is reflected in the said order. At no point of time the petitioner had challenged the same. First of the petitioner also did not respond to the order to the notice under section 148 capital A within bracket B of the said act. So, in fact, when intimation was given to the assessee for completion of assessment in accordance with procedure of section 144B of the Income Tax Act of the said act, with a notice dated 30th January 2023.
I have participated there. I have responded, participated.
And raised this issue.
Raised this issue.
Where is that showing?
Kindly come to 178. This is in furtherance to my earlier response. The response box is there, my lord will find. Sir, in continuation of my response, I like to say that if my purchase is bogus, then
One sir, which page, Mr. Chakraborty?
178.
a box is
Yes,
there.
in continuation.
Sir, in continuation to my response, I like to say that if my purchase is bogus, then my sales are also bogus, and I have paid the tax.
No, you have challenged, you have questioned it.
The
You
last
did not ask for this.
no. I have they are asking for the information. It is not there.
Consider no.
It is not there. It is not there.
That is the only thing he's saying. In fact,
So I responded, but I not asked for.
matter may be, Mr. Chakraborty, there are several matters you come across. Some are good on merits, some are not so good on merits. But you have to argue all of them.
My lord allows me.
But you have to argue all of them. Some may be on a different merit. On the main merits, it may be very
If
good.
my lord allows me, one word only. It is not my responsibility to ask for.
It is obligation. Very well. That
It is
is
his obligation to supply along with the notice. For this, I need not to show judgment. There are plenty.
On the other side also,
No,
plenty.
no, it is his obligation
No, no.
to provide that copy with the notice.
For your benefit.
And if, my lord, it is an incurable defect. It cannot be cured in appeal. How?
The petitioner did not seek for
আবার তো চাইতে হবে।
the aforesaid documents.
হ্যাঁ, আবার copy চাইতে হবে। আবার। এটাই বলছি।
As and by way of an afterthought, that too, after expiry of the period for preferring an appeal, the present writ application has been filed. The writ application deserves to be dismissed with cause. Heard the learned advocates appearing for the respective parties and considered the materials on record. First of all, admittedly, it may be noticed that the order of assessment issued under section 147 read with section 144B of the Income Tax Act of the said act was preceded by proceedings issued under section 148 capital A of the said act, and not only a notice under section 148
AB.
A within bracket B of the said act. If I say AB, on several occasions, both have been made in brackets, so I have clarified. A within bracket B of the said act. কি বললাম? Not only a notice under section 148 within bracket A within bracket B of the said act was issued, but an order was passed under section 148 within bracket 148A within bracket D of the said act. First of the petitioner, however, did not respond. Was passed. First of passed. First of the petitioner, however, at no stage had responded to the said notice under section 148 capital A within bracket B of the said act. Full stop. The disclosure made in the order of assessment were all disclosed in the notice under section 148 capital A within bracket B and the order under section 148 capital A within bracket D of the said act. Full stop. Admittedly, the petitioner has a remedy in the form of an appeal. Full stop. Now, be that as it may, বলে বলবেন, তাহলে অসুবিধা হয়, prejudice হয়. Be that as it may, petitioner has an alternate remedy in the form of an appeal. So I am of the view at this stage, I am of the view that all these points can be agitated by the petitioner before the appellate authority. Full stop. Having regard to the same, I do not find any reason to entertain the present writ application. First of the same is dismissed. There shall be no orders to cost.
Only one indulgence I am seeking. Subject to what my
If it shall be open to the petitioner to challenge the same in accordance with it shall however be open to the petitioner to no, দরকার নেই. He has not asked for that.
My lord, only one indulgence I am praying for. If I prefer appeal, statutory appeal, my lord, one direction that appellate commissioner will consider my this prayer of document or information, because after today, he may not consider.
Better then.
He may not consider.
না আমি ওটা রেকর্ড ওখানে বুঝেন petitioner has a alternate remedy in the form of appeal. I am of the view that if the petitioner makes an application before the appropriate authority, before the appellate petitioner, I am of the view if the petitioner prefers an appeal and makes an application before the appellate authority, praying for disclosure of documents
And informations.
and or further information and or further disclosure of documents and or further information, it shall be open to the appellate authority to consider the same, having due regard, consider the same. Full stop. And that is sufficient. I could say.
No, after today's order, if I make this prayer.
I know that's a consider the same. In view
Deeply.
thereof, the appeal, in view thereof, the petition, in view thereof, with the our observation directions, the application says disposed of. Dismissed.
Not gone into the merits, all points kept
Disposed.
open.
Huh?
Not gone into the merits, all points kept open.
I made it clear that this court has not gone into the merits of the case and it shall be open to the petitioner to raise all points before the appellate authority, if so advised.
Affidavit of service. My lord, affidavit of service we keep.
All formed part of the disclosure made in the 8AV and the order dated.
Deeply.
86.
Lordship, a short point is in your lordship. My appeal has been rejected only on the ground of delay of 33 days. It's an appealable order, lordship. I have furnished sufficient medical reasons.
Appealable order.
Yes, ma'am.
Which one? Which order is appealable?
Well, appeal to the tribunal, ma'am. The appeal was, my lord, rejected. My lord, he was asked, there was a delay
107 was dismissed on what ground?
for delay, my lord. He was asked to furnish my
33
lord, explanation for the delay. He
It's a delay of
submitted,
33
that
days.
was considered and thereafter rejected. Lordship,
Considered only on the ground of rejection is only on the ground of delay.
51. Page 51 onwards.
I am covered by a judgment of this honorable court also.
Show cause was issued and thereafter it was rejected.
His finding is bad.
কিছু নেই দাদা।
I know you say told me that he has considered he has not considered that. He
Yes,
said that same thing. 3 months.
No, my lord, not that.
Page
Will
52.
kindly take page 52, my lord.
Yes.
Starting. Moreover, as per the provisions of subsection so and so, the appellate authority, on being satisfied that the appellant was prevented by sufficient cause from presenting the appeal within 3 months, he may allow the appeal to be
presented within a further period of 1 month, and that further period of 1 month was also passed in the instant case. In
That is
this
his
connection, the
contention.
appellant was asked by registered email as available in database why the appeal application should not be entertained, if that is even after that 4 months. And the date of hearing was fixed on so and so. On so and so, the proprietor of the firm appeared and submitted an application along with copy of the medical certificate, wherein it was found that he was suffering from extensive pain lower back.
What more, sir, you require, sir? You tell me.
Thereafter, he has set out the turnover of that firm for that relevant period. And the reason was given, it was a reasoned order, my lord, subject to lordship's consideration. Thereafter, he has said that for that period, he could continue the business but could not file the appeal. That was the ground taken. Lordship will kindly take the table. This is for the period that he says that he was engaged, he was suffering from back pain and all. It appears from the above table, just below the table, that the appellant did not close his business for the period from September 23 to February 24, but due to back pain, but back pain did not obstruct his day-to-day business activities. That was the reason. Conclusion. It is a reason order. It's not like he has just outright rejected it. Rest, my lord, with
You want
this,
to use
leave it to
affidavit?
Lordship.
You want to use an affidavit?
I leave it to lordship.
Lordship.
What did you challenge? What was under challenge?
So that's only rejection, Lordship.
Sorry?
Oh, challenge, Lordship, with regard to the discrepancies between, purchaser GST bill and
Which order is under challenge? Show me that only. Only the order under challenge. Don't tell me page 52, page 51.
no, not show cause notice. 86, Lordship.
This order
20,
for
Lordship.
DRC 7.
Order DRC 01 A, that is on page 28.
What is 34?
Huh?
What is 34?
Order for DRC 07. Discrepancies under section 73 of the GSTR. Yes, Lordship. Lordship. This is my past revenue matter, Lordship. I tender my apology, Lordship.
I not say my the junior member of the bar. Well, they should be careful. Lordship, kindly see
Oh,
that
Lordship, there is one mistake, Lordship.
I did
Lordship,
not point it out, my lord.
short bits of the
There, Lordship, there is one mistake, Lordship. I have already prepared
And the synopsis.
No, synopsis is correct, I think.
Okay, sorry.
Only short list of dates.
But this has become usual practice now. Let me just.
Comprehensive and short.
চাইলে দিয়ে দিচ্ছি এই দেখো বানানো আছে টাইপ সেন্টার করে আচ্ছা মানে রিজেক্টেড দেখো বন্ধু বাবা সিএফ
But 20th of February.
ওইটা অর্ডার 07 07
No, sorry, I'm sorry.
Adjudication. Adjudication. Adjudication.
Yes, 07 Yes, yes. না না Yes, yes. কিছুটা ডেবিট মেরেছে স্টে জুড়ে দিয়েছি ডেবিট লেজার করেছে হ্যাঁ সেটার জন্য তো
Your 939. Let's find out. 6th of page 41, 6th of February 24. Dismissed on 8. This is the acknowledgement. Sixth of February. It's 51 table. I need that.
Yes, yes. 36 8 plus. No. আচ্ছা
44.
এটা তো
His reply is page 45.
এটা তো শোকস নোটস পেজ 29 এ
By the order. There is
এই মেলটা এসছে
একটা আছে
টাকাটা ফেরত দিয়েছে সিডিবি আছে এটাকে check করো।
Appellate authority.
Yes, Mr. Siddiqui. 6 weeks.
প্রেয়ার বিটা কি আর বলবো? প্রেয়ার বিটা টাকা কাটা টাকা কেটে নিয়েছে 5 লাখ। Lordship, one indulgence, Lordship. The amount of rupees 5,16,348 has been credited, debited from my account. Liberty may be granted to seeking refund of the said amount.
Let them make an application, the appellate authority will.
I have a copy of the mail also. In prayer B also, in prayer B and in the writ petition also. Prayer B in page 14 and writ petition. Paragraph 14 and page 8.
Paragraph 14, page 8. The credit ledger.
Dismissal of the posted appeal. When appropriate application is made, before the appellate, such fact, by the appellate, by disposing of. Succeed there, you do not succeed for you.
Every place service. Lordship, every
John Yadav.
87.
This is my application. Well, we are challenging an order made under section 148 AD. This matter is, in fact, I must tell you, Lordship, is a lesson for all of us that don't make investment in the name of your wives, otherwise your wives would be put to trouble if they are homemakers. A homemaker is an assessee before Lordship. He is the petitioner. The husband of the petitioner purchases property jointly in his name as well as in the name of his wife. PAN of both the purchasers are obviously indicated in the deed. My lord, the 148A(b) notice is issued that you have made certain purchases in your name, however accounted for. The petitioner immediately replies to the portal that this property has been purchased by my husband and this is the PAN number of my husband.
Item number.
The department thereafter passes a 148A(d) order, ignoring the fact that the PAN number of the husband is available with the department. The department is aware when the deed was registered before the registrar, the jurisdictional registrar. Husband and wife, both. The wife is being sent notice that how could you have invested in this property? Where is the source of your funds? When the husband purchases the property out of his funds, jointly in the name, his name and his wife. Clear disclosure is there. We have.
But your lordship.
My lord, sorry. Right.
Right, right, right. Man, I'm sorry, man, I couldn't follow your lordship. Yes.
Yes.
Huh. But here we are challenging 148A(d) itself.
Yes.
Yes. Malad, your lordship will kindly just 2 or 3 pages. Kindly take the 148A(b) notice. Chief Justice's order. কোনটা? না এটা তো অন্য, এটা তো অন্য। This is not an appellable order.
No, no.
This is not an appellable order.
Yes.
No. No. Malad, then Malad stay the order. Wait.
But
Malad, Malad,
but the order which was impugned below.
very well, Malad. Malad, 148A, Malad, 148A(d) order has been stayed on the ground that, my lord, it has to. This is one such order. My lord, this is one such order. It's by the Honorable Chief Justice. When jurisdictional issue is involved, something like that is involved. This is one such order.
Yeah, I appeared.
Already appeared.
I appeared.
Where jurisdictional issue is there.
Paragraph 8, page 2.
What are your challenges?
My lord, on this ground alone, my lord, that is why I want to take your lordship through the notice under section 148A(b). My lord, kindly take, my lord, annexure to 148A(b). Page 22 is the 148A(b) notice. The assessment here involved is 2021. Now your lordship will kindly take, this is extremely interesting. My lord, these are the purchase and sale of securities. Admitted, not taxable at all. Explained in the reply. Then SFT 012, purchase of immovable property, SFT 012. My lord, the department is aware the deed was registered in the office of district sub-register South 24 Parganas 1. And then, my lord, I give my reply,
number also.
which is at page 25.
10 number also. TDS কেটেছে 10 number.
ঠিক আছে। My lord, kindly take. I prefer not to submit return. My lord, your lordship will take the reply at page 25. I prefer not to submit return under section 147 of the Act. Further, in respect, my lord has got that. I'm so sorry, my lord. I should have waited. Further, in respect of purchase of immovable property amounting to rupees 45 lakhs, I like to inform you that the said property had been purchased by my husband, Mr. Shogato Dotto. Page 25.
25.
My lord, my reply, which is against the column remarks. My lord, I am reading the last 5 or 6 lines. From I prefer not to submit return because my return income is not taxable. Further, in respect of purchase of immovable property amounting to rupees 45 lakhs, I like to inform you that the said property had been purchased by my husband, Mr. Shogato Dotto, Vide PAN number so and so, from his own sources of income. And I am only a co-owner of the property. This is for your information and necessary action. Then, my lord, kindly take 148A(d) order. One property and all other are stocks. From my lord, obviously through stock exchange. But nothing, everything explained. But this is a lesson for all of us that don't make investment in the name of your wife.
Only paragraph 5 of the order.
74 is including 45 lakhs of the immovable property. Unbelievable how the department is acting.
Well, lordship kindly says paragraph 5 of the order, 148.
Page 29.
Paragraph 5.
Page
Excellent paragraph.
Page 29.
The submission of the assessee is carefully perused. The assessee did not
assessee-
submit any evidence in support of our claim. What would I submit? He knows that the deed has been registered in the office of sub-registrar, Alipur.
And they have the authority has to
And
give-
10 number is available. 10 number quoted in the 148AB annexure.
For the purchase and all the document, my lord, he should have, my lord, submit before.
Document. What I will submit?
Again, understand.
Yes. Yes.
A homemaker, my lord, the notice issued, had to participate in proceedings, and now we are before your
To
lordship.
hear out the matter, my lord.
Yeah.
Here. Yes, yes.
And 140 notice case this করে সেই পয়েন্টটা বলছি ছেড়ে দাও ইউনিটে পরে 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 নেওয়া আছে second. Well, the order is at page 8 sorry 29.
27, my lord.
It is annexure P3. It starts at page 27, my lord.
Yes, you are in respect of the assessment. We are right.
2021.
Under clause of this constitution. Transactions which achieve law. 45 minutes.
Standard order হয়ে গেছে কোনটা শুধু অ্যাডমিশন হবে সেটা সেটা হবে না এটা শুধু হয়ে গেছে মানে কি করতে গেছি সেটাতে ঠিক আছে সেটা টাইপ করবে সেখানে স্পট করবে সেটা এই ফ্যাক্টটা তো হচ্ছে না
And the bad number of petitioners asking for.
Yes.
Extending the opposite. The identity.
Malad the jurisdictional assessing officer. Assessing officer.
And by recording. Yes. Passing. That yes, it needs to be. That's what she said. In respect of the assessment year 2021 as its state. As in of section 147 of the section. Peacefully. Other section say that in otherwise not applicable. Some of the new applications in the world. To certain later, it is not application.
2 weeks after vacation.
2 weeks thereafter, my lord.
The document
Yes,
যদি
yes.
সাবমিট করতে পারলাম পুরোটা পুরো
Very well, 2 weeks thereafter, my lord. 2 weeks, 1 week thereafter. Within Well, 2 weeks after summer vacation will take us to 20. Yes, yes.
Change হবে, আমি বলছি।
Notice is at page, my lord, 30, 31, 31. There is one more issue. The JAO or the jurisdictional assessing officer, in view of the faceless assessment scheme introduced by the CBDT in terms of section 151 capital A, jurisdictional assessing officer can no longer issue the 148 notice. It has to be issued from the faceless assessment center. That issue is also there. And my lord, there is that issue is now pending before the Honorable Chief Justice. The judgment we have just handed up. That is the issue involved in that case. And it is pending before the Honorable Chief Justice. And the Honorable Chief Justice has been pleased to stay all the proceedings. ছেড়ে দেয়া দরকার নেই। আমাদের হাইকোর্ট আছে তো। It is on the basis of the scheme of 2022 in terms of section 151 capital A of the Act.
Yes.
Surely, my lord.
151.
Surely. And my lord, there are now 2 High Court judgments, one rendered by Telangana High Court, another rendered by Bombay High Court just very recently, my lord, just 10 or 15 or 10 days ago, holding that, my lord, kindly take holding that after the commencement or introduction of the faceless assessment scheme, in terms of section 151 capital A of the Act, the faceless assessment officer, the jurisdictional assessment officer can no longer issue a notice under section 148. Can no longer. In that, my lord, kindly take the Bombay High Court judgment. Kindly take, my lord, issue number 4.
Section and then
Certainly, section 151 capital A. আমাদের পয়েন্টটা
This
কোথায়
is
আছে?
pending before the division bench.
My lord, kindly take. No. It's
My
okay. It's okay. My lord, kindly take section 151 capital A. The central government may make a scheme by notification in the official gazette for the purpose of assessment, reassessment, or recomputation under section 147 or issuance of notice under section 148, or conducting inquiries or issuance of show-cause notice or passing of order under section 148 capital A, or sanction of notice of such notice under section 151, so as to impart greater efficiency, transparency, and accountability by eliminating the interface between the income tax authority and the assessee.
It has been introduced.
Yes, 2020. But that is there in 2022 scheme. I do not have.
That scheme really takes away the power.
Yes. Because it's a statutory scheme. এখানে মানে kindly take of the writ petition, page 32. We have annexed that. This is the, my lord, the notification issued by CBDT. Kindly take, my lord, 3B.
Yes.
Automated allocation. It cannot be issued by the JAO. So this is another issue.
and the notification dated 29 March 2022 of the notification submits that in terms of section 151 capital A of the said act, this scheme has already
আমার writ petition টা কোথায়?
of 3B of the said scheme. It is the issuance of notice can only be made through automated allocation in accordance with the management strategy formulated by the board as referred to in section 148A of the said act. In a faceless manner, except provided in section 144 capital B, provided in section 144 capital B of the said act. deference to making assessment or reassessment of the total income or loss of the assessment. Having regard to the approach that it is submitted, that the jurisdictional officer not have so notice under section 148 capital A within bracket B of the SEDAC.
148 only. 148.
148.
Well, after the conclusion of
48 of the SEDAC. So having regard to the SEDAC, so we enter into the SEDAC and the proceedings of this are because of the proceedings on the basis of for submission.
দরকার নেই বলছে তো
Lordship, my lord, be here. Yes.
Otherwise not applicable.
not applicable, not applicable.
And taking into consideration the jurisdictional disparities by Mr. Pudikar, I am of the view that the application
Yes.
Well, stay of the order.
Yeah, that is.
in state for a period of September.
So grateful.
My lord.
Great. The notice and the order has to remain state. Both the notice and the order. 148 a deed order and
And the notice.
under section. Subsequent proceeding.
We are challenging in the present application, the appellate order, my appellate authority passed the order, my lord. There is no appeal, my lord. Because
I couldn't follow. Sorry.
We are challenging the order passed by the appellate authority. But there is no appellate, this is not an appealable, but this is an appealable order, but right now there is no tribunal constituted under the GST.
Yes. What is the challenge?
We are challenging because of the reason, my lord, they have basically affirmed the adjudication order.
What is the original order?
Original order, they are saying that there is a mismatch between 2A and 3B, my lord.
So what happened thereafter? What order was passed?
Then, my lord, I prefer
Section
an
73 order was passed.
Yes, my lord. Against that order, I prefer an appeal before the appellate authority. And appellate
Or
authority.
you are which order you are challenging? Original order 10th May 2023.
Yes, my lord.
Page 27.
Oh, yes,
And the
This is
order
the-
passed by the appellate authority, which page?
My page, my lord, kindly come to page.
Appellate authority's order is at
My lord, last, page 36.
36 and 37.
36, my lord. You start from page 34. Kindly come to page 36.
What is the ground for challenge?
My lord, because my lord, there is a circular, my lord. My lord, three things, my lord. There is a mismatch between the 2 and 3B. They have asked for the reconciliation of the mismatch. We have submitted document, but before the appellate authority could not submit it, but due to there is a mistake on the part of the consultant, he could not submit the documents, my lord. It is required to be submitted because the reason, my lord, he could not, 2-3 occasion he missed the bus, my lord. This is the actual fact, my lord. Kindly see the order, my lord, observation and proceeding of the adjudicating
I'll
authority.
keep it after the vacation then. Then if I admit it, I'll direct him to pay secure
20% of the
addition.
dispute, if I go to the
But I
appellate,
will keep it after the vacation. If in a motion stage, it can be disposed. Give it a short point. If he has not submitted the document, send him back only.
The case is
I will not, although, you see, although at the end of the day, the tribunal is there, but High Court, so judicial, at the end of the day, it's exercising powers of judicial review. So why will factual aspect is that is let the tribunal, let the appellate authority consider, or keeping it after the vacation, Mr. Modin.
in the meantime, my lord, because order has been passed in, I think.
It's a motion. As a motion, it will appear.
No, my
No, only-
only says in the meantime, they should not proceed with the.
We are ready to pay 20% of the demand, my lord.
So then I will admit the matter. Then the admit means
We'll file
Well,
affidavit.
kindly fix the particular date so that.
no. But if it is, you see, considering the fact that there are several motions, I cannot fix a date for the motion.
It's a very
Otherwise,
short matter, but only
that
I
is
have
why I
to
said
show-
I'll keep it in the under the same list and I hear out.
Meantime, my lord, the authority will bound to take the action, my lord.
If they come, we'll give, press for this, mention this. I'll take it up after the vacation. 15 days, anything will happen.
We cannot, so auto generate everything, my lord. They have to.
Because the appellate's authority
Very
order
well,
is of 12th
very
of
well,
December
very well. Challenging the order, challenging an order passed under section 107 of the said act. Challenging an order dated 12th of December 2023. 12th December, sir, kindly check Mr. Mojumdar.
Yes, my lord. Yes,
Passed
written,
under
my lord.
section
Page
107
36.
of the said act. The present writ application has been filed. According to the petitioner, since the appellate, according to the petitioner, although the aforesaid order is appealable under section 112 of said act, no, প্রথমটা ওই the GST, CGST, ওই দুটো করে, herein after the present appeal has been filed, present writ application has been filed. So it is submitted that although the order under section 107 of the said act is appealable under section 112 of the said act, however, by reasons of the tribunal not being constituted, however, by reasons of the tribunal, appellate tribunal, appellate tribunal not being constituted, the petitioner has approached this court. According to the petitioner, the proceedings arise out and in connection with an order passed under section 73 of the said act dated 10th of May 2023 Where have you said that mismatch?
In the repetition, my lord.
Where, which page? Tell me.
Yes, ma'am. My lord, kindly see paragraph 11, my lord. 11. কোথায় বলেছি সেটা প্রথম?
According to
Kindly come to
petitioner-
paragraph 18 also, my lord. 18, 17.
Yes.
And we have stated paragraph 17 and 18 of the writ petition. Then, my lord, this paragraph 18.
According to the petitioner,
Paragraph
the
19.
entire proceedings arise by reasons of a mismatch once in mismatch, what is GSTR 2? GSTR 1 is
Return.
GST 1 is the whatever tax is submitted.
GSTR is outward supply.
Outward supply.
Return. GSTR 3B. Here is a mismatch of GSTR 3B and GSTR 2B. GSTR 3B is the
Will be auto 2B will be auto populated whatever is there in
populated
GSTR 1.
input tax credit.
Oh, that is input tax credit.
Input tax.
And is
Whatever,
propo-
and GSTR 3B is the monthly statement or quarterly statement of the all the details. Input tax.
So there is a mismatch in GSTR 2 and GSTR 3B.
GSTR 2 and GSTR 3. 2B and
2B, my lord. 2B and
GSTR 2B and GSTR 3B.
3B.
You will know.
Between mismatch in GSTR in filing of form numbers GSTR 2B and GSTR 3B. First up, the petitioner submits that no, according to the petitioner, now Mr. Mojumdar, by where is the circular?
The circular is
Which says that this has been kept in abeyance.
Yes, my lord. Starting from, my lord,
That is your case. That
Yes,
by
ma'am.
reason of this circular could not be
ma'am.
disclosed.
Yes, came. No, they cannot proceed because of the is kept in abeyance. So that is why they cannot ask for the
According to Mr.
reconciliation.
Mojumdar, now Mr. Mojumdar, learned advocate representing the petitioner by placing before this court the circular number 26/2017 dated 29th of December 2017 appearing at page number
সবাই আছে এখানে। Page 40.
Where is this? This is not there?
Circular 47. 57. Sorry. Well, December, it is clarification has been given, page 20, starting from page. This was circular number 3711 of 2018, dated 15th March 2018 at page 43. A clarification mismatch, my lord, kindly come to page 57, dated 27 December 2022. That is our period is 2017-18 and 18-19 is reflected.
No. Number.
Our period is 2021, my lord. So kindly see page 57.
Page
57 of the writ petition. Since subsequently that has been clarified on 17th July 2023, that is page 62, my lord.
by placing before this court the notification dated, circular dated 27th of December 2022. বাকি ওই লেখাটা কাটা হচ্ছে। And page 57
এখানে বলছি appeals কোথায় রেখেছে?
of the writ petition
করবি না?
submits that the clarification has been issued by the department by the Central Board of Indirect Taxes and Customs, by the Department of Revenue, Central Board of Indirect Taxes and Customs, as to how the cases
সার্কুলারটা কোথায় রেখেছে? সেটাই জিজ্ঞেস করছি। সার্কুলারটা কোথায় আছে?
with difference in input tax credit availed in Form GSTR 3B as compared to that of details in Form GSTR 2A shall be dealt with. So we submit that the aforesaid clarification had been issued for the financial year 2017-18 and 2018-19, which is the relevant year.
Yes, one.
For the
Subsequently,
petitioner.
then also then again clarified on
Unfortunately, the petitioner could not place the aforesaid notification before the appellate authority. Full stop.
I have that all the documents.
Full stop. It is for reasons as aforesaid. It is for reasons as aforesaid. Appellate authority. Paragraph. Mr. He prays for stay of operation of the order dated. Where is the order?
Miss
Order dated
12 December 2023.
12 December 2023. And submits that he is ready and willing to comply with the provisions of
112, my lord.
Section 112 subsection 8 of the said act. So Mr. Siddiqui, learned advocate, enters appearance on behalf. You're there. Who's that? Mr. Siddiqui? Mr. Siddiqui, learned advocate, enters appearance on behalf of the respondents, having heard the learned advocate, all the respondents.
All the respondents.
Having heard the learned advocates appearing for the respective parties and taking note of the fact that no appellate authority has been taking note of the fact that the appellate authority under section 112 of the said act is yet to be constituted. I am of the view that the writ application should be heard. First of further taking note of the fact for writ application should be heard. First of further taking note of the fact writ application should be heard. So the petitioner is accordingly directed to deposit a sum of rupees to deposit %20 of the remaining amount. Deposit 20% of the remaining amount of the tax in dispute in addition to the amount paid under subsection 6. Entire amount you are ready and willing, I have said.
In addition to the amount paid under
You are ready and willing to pay the entire amount.
In addition to of the disputed tax, my lord.
Naturally, in addition to the amount paid under subsection 6 of section 7 of the said act, 107 of the said act, arising out of the said order. First of all, if the aforesaid amount is paid by the petitioner with the GST authorities on or before. Yes, sir. On or before?
10 days, my lord. 10 days.
On or before 10 days. I take 10 days. On or before 30th May. On or before 30th of May 2024. Any demand is there? No.
automatically it is credited.
Automatically.
The demand, if any, arising out of the adjudication order dated 10th May 2023, which has since subsequently been merged with the appellate order dated 12th December 2023, shall remain state for a period up to the end of August 2024.
Great.
Full stop. The party shall be at liberty to rely, the petitioner, the respondent shall be at liberty to rely on the records of the case when the matter is taken up next. No. Yes. Let the records of the case be produced when the matter is taken up next. This matter for further consideration. This matter under the heading hearing in the monthly list of July 2020.
Great, madam.
Your Honor.
89. I am for the petitioner, my lord. My lord. My lord, I have challenged my lord assessment order, my lord. My lord, what happened, my lord? The petitioner before your lordship is a housewife, my lord. He has no income, my lord. He has not filed any return under Form 16, my lord. Her, my lord, husband purchased a flat from the income of his husband as well as, my lord, by taking loan from the bank. And to that effect, my lord, husband has submitted the Form 16 before the authorities. My lord, since
Same case, Mr. Durdoria.
My lord,
Difficulty,
here,
assessment order has already been passed.
allow me.
Here, assessment order has been passed, my lord.
An affidavit order.
It's an appellable order, my lord.
My lord,
My lord,
now,
that was
my
passed in 23rd,
my lord,
28th March, my
so-called
lord. He has
notice was
filed.
issued, my lord.
He has
I have-
participated also, my lord.
I have also responded
Let
to
him-
so-called notice, my lord, categorically stating that I am a housewife in spite of the, and in the so-called notice, my lord, they have stated that I have.
I'll take it up after the vacation. Let this list this matter along with, what is the matter name?
So that was item number 87.
WPA. List this matter along with.
Now, my lord,
I'm just checking.
there is a mistake
That is,
on my
my lord,
part, my lord. In my petition, my lord, one single document I have not accessed.
WPA number, my lord.
I have prepared a
116.
submission to that. Allow me to file this, and I am submitting a copy.
11692, my lord. Debok Priya Datta.
As prayed for leave is granted to the petitioner to file supplementary affidavit. Let the supplementary affidavit as filed in court today be taken on record. Full stop. Let this matter appear along with, since the issues involved in the present application are similar to those in WPA
11692.
11692.
Debok Priya Datta versus
of
2024. 11692 of 24.
Let this matter appear along with WPA such and such. Full stop. List this. কবে বলেছি ওটা?
But that was not monthly list of August. Because
Monthly
affidavits were given no direction. Monthly list of August.
Then, my lord, my lord,
No, my lord. Lordship will kindly.
Silly.
obviously, my lord. Otherwise, my lord, I will be.
The assessment order, my lord, let him.
My lord, I will be penalized, my lord. There is I will show you, but there is a judgment of
Lordship will kindly.
Bombay High Court also, my lord. My lord.
So far as this matter is concerned, yes. Considering the peculiar facts of this case,
Yes.
considering the peculiar facts of this case, and taking note of the fact that further proceedings in WPA number such and such,
Yes.
11,000.
in connection with the notice issued under section 148A, 148 of the said Act, has been stayed. Let the respondents be restrained from taking further steps in connection with
But here 147 order has been passed.
in connection with the order issued under section 147,
Dated 28th March.
147 read with section 144,
Yes.
B or no B is there. 144 dated 28th March 2024
Yes.
20th March.
for the assessment year 2015-16 be stayed till the end of.
But in that case, it was for the
Same order.
September and the affidavit direction. my lord.
Let affidavit in opposition. No affidavits.
Not-
The respondent shall, however, be at liberty to
If some required, my lord.
to file affidavit in opposition?
Well, let him submit a copy of the supplementary.
Well, I have already served one.
Where is the notice under section 1? Where is the notice under section 148?
Well, assessment order, my lord.
Wait,
No, notice. Page 65.
issued by whom?
Just that point, not issued by.
6, my lord, page 7, my lord.
No, it was jurisdictional officer. My lord. Jurisdictional officer.
Ward number 27.
When?
But date is, my lord,
Date is
14th April 2023.
2022.
22, sorry. 14th April.
Monday. I'll take it up on Monday.
Yes.
Monday,
This will be stayed on that ground.
Yes.
My lord.
It's proceeded by the jurisdictional officer. So proceedings are arising out of the order passed by the jurisdictional officer.
But that matter is pending. Your lordship will kindly have a this. Not the stay has been granted, but it's pending. But if since lordship will kindly pass a similar, we'll file affidavit. And
No, I will consider that on Monday and pass it. I should not pass a blanket order. I will consider and pass.
Mal.
Come here on Monday.
Monday.
Will be called on, sir.
But today, my lord, he has filed lordship kindly pass some order.
Let supplementary affidavit filed in court today be taken on record. Let a copy of the same be made over to the learned advocate representing the respondents. Full stop, list this matter for further consideration under the same heading on Monday. Date diye do.
Mal.
I will examine the case and then let me find out. Sir, have you taken this point?
They have not taken that.
Well, only, my lord, I am a housewife. That portion I have challenged, my lord, and my lord.
Find out from Mr. Dodoria what is the point.
That point I have not taken.
He will intimate it. You have
Well,
to
I'll
bring it on record by way of an affidavit. Take back your supplementary affidavit. File afresh. I think it will be better. Repeated supplementary affidavits will not help. Or else, the point of law. Point of law can always be taken.
And your lordship may take after the vacation, but if they want.
No, I'll keep it on Monday.
90.
Good, I'm appearing for this.
Last I am for the case. A very innocuous prayer, my lord. Challenging.
That makes it more difficult. Whenever a prayer is innocuous, it's difficult to get that order.
No, my lord. Very small. I am challenging the only demand notice under the assessment for the assessment year 15-16 because 148A notice issued, submitted reply, D order passed, 148 notice issued, return submitted. Thereafter, they issued 142-1 notice. Rightly, I submitted my details reply with books of accounts. Law says if it is adverse to the prejudicial interest of the assessee, they will issue show cause notice and draft order. But in that case, they rightly not issued because in the assessment order, they accepted my contention and said there is no demand, no adverse finding. But while calculation of the notice of demand under section 156, they raise some demand. And categorically stated in the order.
Rectification application under section 154, my lord. He has not done so, my lord. There are some, he has to file application under section 154.
No.
Rectify.
That will they pending, keep pending for 4 years because law says they will pass order within 4 years.
Unless the application filed, my lord, how can we pass an order, my lord?
Kindly have a look at 69.
Lordship will kindly have a look at section 154.
I have understood his point.
Yes.
He says that although you did not issue any notice because you accept his contention, while issuing the demand, while passing the order, ultimately you raised the demand. How could you have done that? Take instructions, come back on Monday. Take instructions.
One difficulty, my lord. Monday, Tuesday, Wednesday, my lord, I will be appear, my lord.
Very well, I'll place it next month the list.
Yes.
My lord, then, my lord.
And not urgent matters.
Yes, affidavit of service, my lord.
Lordship will kindly record.
Affidavit of service filed in court is taken on record. Having regard to the nature of controversy involved, taken on record, full stop. Having regard to the nature of controversy involved, the respondents are directed to take appropriate instructions in the matter.
Otherwise,
I'll forget it.
Yes,
By way of the present writ application, the petitioner questions, the petitioner challenges. Now, the questions the issuance of notice of demand dated 19th April 2024.
19 March.
19th March 2024 issued under section 156 of the said act. Notwithstanding, where is that?
My lord, order, my lord.
Yes.
Order at page 69, my lord.
69.
My lord,
Notwithstanding,
69 operative part, my lord.
wait, sir. The order passed by the, who has passed this order?
National Faceless Assessment Center.
Order passed by the,
respondent number.
That the assessment order passed by the
Respondent number 4.
respondent number 4 accepts the assessed income as 0 under section 147, read with section 144B of the said act, or Income Tax Act.
Yes.
So having regard to the above, now, heard the learned advocates appearing, কি বলে challenging question, respondents are directed to take instructions. তাই না? হ্যাঁ, তারপর stay is not necessary because proceedings has to be initiated.
As your lordship decide. Because my lord, they are saying, but one side they are issuing notice of demand, then automatically demand is standing. That is why.
My lordship will not stay, my lord, will.
Otherwise, this matter can be disposed of in a single day, my lord.
No, then demand I will stay. Take instructions in the matter. First of,
The lordship will fix the matter Monday, my lord.
Monday, I will circuit when many matter fixed, my lord.
আচ্ছা ঠিক আছে, stay রাখছি। List this matter for further consideration under the same heading in the monthly list.
Monthly of June, my lord. I'm grateful. Affidavit of service kept in my lord.
ওপরে
এটা একটু নিন।
আর কটা আছে এতে?
I'm grateful.
ডাকো।
91.
Lordship will kindly take it, Lord, on the next day. I'll take instructions, Lord. I don't have.
Urgency is there after vacation, madam.
Lordship, may kindly give us not today, Lordship, kindly.
Is the urgency is there?
It's a refund of TDS
Refund,
matters, but
Lordship.
I will take instructions, Lord.
Mr. Rai, learned advocate, prays for an accommodation to take appropriate instructions in the matter. Having regard to the officer, let this matter stand adjourned and appear in the month list of June 2020.
Lordship, they have just issued a demand, Lordship. Meanwhile, they should not take any steps with respect to the demand.
Monday then. If she wants on Monday, my Lord.
Nothing will happen. You have to proceed against you. If anything happens, come back.
We'll do that, Lordship. Lordship, meanwhile,
Petition
our
is pending now.
Yes.
Although you have no control, that is a different issue. But writ petition is pending now. If anything goes wrong, this court is competent to.
Very well, Lordship. Lordship, may kindly take the affidavit on service on record, Lordship. Affidavit. of
Affidavit
service.
is filed in court is different.
92.
I'm waiting for the union of.
That is senior appearing on court number 9. So please sort first.
After vacation, madam. Madam, no urgency.
After lunch.
After vacation, madam.
No, sir. After lunch.
What is the urgency? Madam, I cannot wait for this. Unless there is urgency, I'll take it after the vacation.
Challenging the appellate authority order, my lord, they filed this writ petition. It's a case of refund. They are asking for refund. The appellate authority is rejected.
Very well. You take instruction in the matter. Since an accommodation has been sought for on behalf of the petitioner, let this matter stand adjourned and appear in the monthly list of June 2024. The respondents are directed to take appropriate instructions in any case. হ্যাঁ ডাকুন
93. 93 of
If
the
anything
same
happens, you come back. Difficulty is there, you come back.
Number 94.
93 কি হলো?
My lord, say issue, see, my lord,
Same order.
here, Different years.
My lord, 94 and 95 are the same SSC, my lord, for the two tax period, my lord. But these are the matters, my lord, under my lord, the 168A, they extended the period by way of notification. The lordships deal with the one matter. By way of notification, that my lord, they have extended the period. We have challenged the extended period, that there is no justification. Your lordship passed an order.
I did not in this matter.
Yes, my lord?
Have I decided?
Yes, my lord. Your lordship.
This matter-
Not finally decided.
Not finally, the infimor has been passed. My lord, may I? My lord, 94, in the matter of 94, there is a my lord show cause notice. That has 95, my lord, in the item number 95.
Then I'll come back.
My lord, yes, sir.
I'll come
Only
back.
thing, my lord, the virus is being challenged, whether it has been served to the advocate.
Oh, virus has been
My
challenged.
lord, may I? My lord,
Then no interim order, sir.
may I? My lord, I don't. My lord,
Give it up.
My lord, may I? My lord, your lordships on the last occasion, my lord, mold the prayer. My lord, I write the my lord, the molded prayer. I wrote the my lord, kindly take my lord, kindly take the my lord.
Challenge 168A. The action is good. My lord, if he says the one.
I'll come after the.
Yes.
My lord, there's an order passed by the my lord,
After
your lordships
recess.
and the my lord, the
My lord,
coordinate bench, they have not appealed. They have not appealed against.
my lord, I have been told, my lord, in a matter where I had assisted a great lawyer, where I was told what to say, like extension of interim order or vacating of interim order.
And my lord, now he has been my lord, acquainted, my lord, but my lord, appeal has not been preferred against the my lord, judgment of the coordinate bench. Grateful, your lordship. And this is the same assessee but the different one. 95 first one.
confused করে দিচ্ছি দাদা।
94 এ প্রথমে reading
হ্যাঁ,
ভুলটা করেছিল।
হ্যাঁ, there are 95 বুঝতে হবে।
Item number 95, my lord. The show cause, my lord, was served upon me in the month of March. But by the order, date of order should have been, my lord, under the statute within the 31st of March. There should be 3 months time under section 73. Your lordship passed this order on the same matter, my lord, in the show cause notice.
দাদা একটা দেবে গো দাদা।
তুই তো নিশ্চয়ই তো।
তোমার মতো কি মেমোরি আছে আমার?
একসাথে দেখি।
কোনটা রে? 12074 পরেরটা একটা কিন্তু খেয়াল রাখবো।
Yes, 18 March, 15 January ছিল ওটা। And in this case, the show cause notice was served upon me or my lord through Procedural, my lord, on 18th of March 2024. For the period 2019-20.
Paragraph 6, it should be 73-9.
73-9, my lord.
Should be 73-9.
73-9. My lord, I'm forward to your lordship. This should be 73-9. 73-2 read with my lord 73-9.
Paragraph 6.
Paragraph 6. I am on the paragraph 6 accordingly, according to Mr. Ghosh, my lord.
Yes, yes.
পেজ দেখাচ্ছে, শোকজ নোটিশটা দেখাচ্ছে। পেজ DRC 01
State.
And this issue has to be decided by your lordship, my lord. Till date, my lord, I am waiting for the, my lord, the opposition from the other side.
You filed show cause.
My lord, they have, my lord,
In this matter, if I, response to the show cause.
show cause. I have not, no. On 2019-20, my lord, I have not. Till date, I have not.
73 তো।
You have not.
I know, my lord. But, my lord, when the, my lord, I have challenged the jurisdiction on the basis of which, my lord, the show cause notice was, my lord, issued, my lord. That this is a question of jurisdiction. Limitation is a question of jurisdiction, my lord. I should not, my lord, plea before lordship. This is a question of limitation, my lord. This is a question of jurisdiction. If the, my lord, the inception is bad, my lord, then the all subsequent event is bad, my lord.
But only thing, my lord, I am not very sure, my lord. He says that this is a trust, but I do not see any documents in support. The trust has come up whether this.
But I am an assessee, my lord.
But, interim order.
No.
Interim order.
Interim order, my
My
lord.
lord, I had handed over.
In two different high courts, my lord, interim order has been passed. My lord, Orissa High Court has passed a.
I had handed over also. My lord had asked for me. I had handed over the order.
My lord, may I, my lord? My lord, this is from the Chhattisgarh, Allahabad, my lord, and my lord, the Orissa.
Chandigarh also.
And now, my lord, our court, my lord, Your lordships and my lord, your lordships, my lord, coordinate bench also my lord passed.
I request my lord, if he, my lord, if prayer A, what is his today's prayer?
Well, I can give you the bunch of the orders my lord on Monday. If your lordship kindly take up the matter on Monday. In the meantime, my lord, my learned friend insists my lord to serve the matter, all the petitions. Insists my lord to serve the my lord, all the my lord advocate general and my lord ISG. Today, my lord, I will serve and come back on Monday, my lord. And he's insisted on
Well,
that.
I am not insisting. That is the rule.
I don't know, my lord.
CPC, that's.
And I'm eager to my lord to decide this issue. Till date, my lord, no opposition has been filed. On the my lord, there is 100 petitions. No one opposition has been filed in this issue, my lord. But my challenge is, my lord, section 73 says, my lord, on a stipulate certain time, my lord, for my lord show cause and the order.
For instance of notice on the.
No, the notification has been challenged. But that is a 168A. Notice.
Notices has been issued, my lord, pages 15 and 16. He said that you cannot.
And subject to correction, Union of India is possibly not a party. If he is challenging a notification of Union of India.
CBIC, I made a party. I served upon them. They,
Union
I will, my lord. Grant me leave, my lord, I will, my lord. But CBIC has been made a party. I served upon them. And they.
Well, ultimately, well, order 23, rule 8. I'm just kind.
Online
Order chapter 23 capital A possibly. Chapter 23 capital A. Mobile.
What is upon it?
Attorney General search করো
Push.
A capital, which order 27 capital A. এটা আমাদের ইলেকট্রিক আসলে কনস্টিটিউশন
আসেন সত্যি
এটা নয়, এটা নয়। এই যে দেখো এটা দাঁড়াও files
এই দেখো এখানে বলেছি the apex court held on bonding apex court held that while consent of
But one A,
one six subject correction. The extension has been done in respect of in exercise of its power under 168 capital. If my learned friend doesn't challenge this notification, then whether, my lord, an action done in accordance with law, injunction can be passed or not. If he doesn't challenge a prayer, my lord, that then his challenge goes. If his challenge goes, my lord, his foundation, he says, then, my lord, my exercise has to be, my lord. My lord, it has to be. That's a very important point. No. My lord, only thing I found a judgment, my lord, Attorney General judgment, 2001 volume 2 SCC 156. It has been held, the apex court held that while considering the question of grant of declaration of para of the as ultra vires by the reason of the same being said to be direct conflict with the statutory, no notice was sent to the Advocate General of the state, and therefore the judgment delivered by the appellate bench of the High Court was not sustainable.
but may I place my order?
My lord, it's a question of law, my lord. But if he, my lord, because my lord friend says he wants to give a go by to this prayer, if he goes by, whether, my lord, an injunction order can be passed on. If he gives a go by to the order first, then my lord, subject to correction.
Because it's not dependent about prayer. About prayer, not dependent of prayer.
My lord, he is actually asking for stay of the notification. He is actually, because if the notification remains, no, if he notification remains, subject to if the notification remains, anything done, the notification it is in terms of 168. He says, but my lord, no, my lord, it is basically, if he, my lord, kindly then record this, that he is giving a go by to this player.
But I will. And in the meantime, I'll serve under the learned ASG and Advocate General. I don't think they will insist about Attorney General because
I cannot insist.
Kindly take order 27A. Can take order 27A 1A. What is the incident? The instrument under the instrument under the act. If I challenge, I can serve on the government period also.
The Union of India has to be made a party.
I will today, I will.
India has to be made.
Today. In both the matters, both the matters are same, in both the matters.
I could not understand. Is my lord pressing for prayer?
Yes. I'm pressing for all the prayers. Service to the Secretary, Finance Department, New Delhi. Department of Finance, Department of Finance, New Delhi. I will. Usually Mr. Maiti is appearing on their behalf. Mr. Maiti is here, my lord. Usually he appeared, but in all the cases of 168A, but I will, my lord.
I am followed up from.
Block, New Delhi, 110001.
সোমবারের মধ্যে সার্ভ করতে পারবেন না
অ্যাড্রেসটা লিখে দিতে
I'm grateful, my lord.
For the order service.
Yes. Wednesday, my lord, I'll come with one of the bunch of orders, my lord, passed by the other High Courts.
I have seen and at ASG to come up and says that minus has to be before the order. Many matters, my learned friend is aware. Let him come, let him come. I cannot take his. There was some kind of my lord.
I will serve upon the
Chief Justice.
my lord, I will serve upon the Ministry of Law.
The office cannot. I am not sure. Attorney General. Well, it is.
Most of the matters we have heard.
That is what we have heard from the Attorney General. Well, Attorney General. Findings of the
This is a statutory instrument under the Act, my lord.
statutory instrument. Statutory instrument.
And my lord, the 96 also same.
Well, let this court be the first court to decide on this issue. Because my lord then has to decide.
He's dropping prayer here too.
No. My lord has to also decide the decisions of the GST Council where this force majeure issue was considered. Yes. Because absolutely, because
in fact, my learned friend was insisting upon affidavits. They are not using affidavit earlier matters. But I don't think affidavit is required in this matter. It's substantial question of law, is it?
My lord, 96 is also same, my lord, for the different assessment.
Yes, this matter will take some time.
94,
95 too.
94, 95 to order হয়ে গেছে।
No, 94 হয়নি, 95 হয়েছে।
94 and 95 the same SSC, but different, same order. And 96 is a different SSC, but it is against the CGST. I have served the CGST, but the point is same.
WBGST নেই?
No.
But we WBST notification challenge করনি তো? There have been two separate notification, one by the
96.
আমরা আছি তো। নেই বলা যাচ্ছে।
96 আছি তো।
আমরা আছি তো, তুমি বলে দিলে নেই?
নেই। অ্যাম্বিশন তো।
থাকে না
CGST কোথা থেকে আসলো? আমরা নোটিশ দিয়েছি।
Oh, no. 96 also same, my lord. Yes, my lord. The same order, same prayer. And my lord, the only thing is, my lord, on the date of affirmation of the, my lord, this writ petition, they passed an order. So, my lord, I prepare a supplementary already served upon them. Already served upon them. But I've already served.
Challenge করা যাবে না।
My learned friend, now the matter is over.
These are all different entities, my lord, so there has to be separate orders. 96 is a different.
But they'll benefit, my lord. We are all beneficials, my lord, to the separate orders, my lord.
Very old colleague of ours, my lord.
97.
Several occasions.
Till 2022.
My learned friend is a stalwart in this.
Then my learned friend come, my lord, Mr. Chakraborty come. Now, my lord, he is taking, my lord, all the, my lord, the technical points he could have, my lord, taken, my lord, to put a lordship, my lord. I'm grateful to you, lordship.
My seniors have my seniors have taught me.
I'm challenging the assessment order passed under section 143(3), railway section 144, capital B. My lord, on the ground that they have not provided with me the VC. VC has to be provided. We have asked for the VC. Yes, my lord. But a VC for personal hearing not been provided. It is written that it has been provided. And there is a multiple judgment, my lord. Supreme Court, my lord, has also relied on their judgment also specifically provides that. And kindly see that page 29. Yes, my lord. No, 140. Yes, my lord. 144B, my lord. 144B, subsection 6, Roman 8. May I read, my lord?
Yes.
144 capital B subsection 6.
দিয়েছে তো, দেখা আমার বিরুদ্ধে টানছিস কেন? এই শোন না, একটা জিনিস হচ্ছে, এটা কি? হ্যাঁ?
ওটাই তো। Where the subsection 6 Roman 8.
এটা grievance।
ওটা কি না? বুঝছো না, আমি বলছি না, just বলে দিতে তো হবে। মানে Roman 8, মানে where the request for personal hearing has been received, the income tax authority for the relevant unit shall. Yes, my lord. My lord, kindly see page 29 of the assessment order, page 29. Paragraph 2, before conclusion, para 3.8 before conclusion. The assessee also requested VC, which was provided to the assessee on 28th March 2024, but assessee did not attend the same. My lord, no assessment. That is what I'm saying. My lord, kindly come to page, my lord, page 16. Page 16. Page 16. But it is VC date and time is 28th March 2024 at 4 p.m. Suomoto. Man, kind listen, man, there is no link, man. VC link doesn't provide me. It is written, but no information, no communication. How can I participate in the proceeding? Nothing is provided. It is screenshot of the portal, my lord. Yes. Yes, sir.
No, only one thing. The link has not been provided at page 16. That is his grievance. But kindly see page, the next page.
That is a
page 17, kindly see.
17.
He has.
That is a different matter. This is a grievance. Page 17 is a grievance. If there is a grievance, I can make a grievance before the grievance authority. That is one created on 20.
Let me say what I want to say. This grievance was raised, on 29th March 2024.
Does not raise a grievance. He has made a request. That is the.
He has made a request, but then in that request, your lordship, he is showing that there is no link. So his grievance would be that there is no link. Yes.
Your department will really. So far as he is concerned, you are not his enemy.
No.
Your department will know whether he has been given a link or not.
Yes. They have
and it is
written in the order.
Then the question of prejudice will come. But first of all, facts must be ascertained.
Yes.
Yes, man. Absolutely.
Very special. That a link is there provided and he says no.
Since it is provided in the order that he was provided the link, he did not come.
No, nothing.
So I don't think the department will change their stand. But I have, they have to justify. Yes.
Before the court. First of all, the department has to justify before you.
I will.
Test out.
Yes, I will find out.
Officer of the court whether this is correct or not.
Yes, I will find out.
On oath, I am made a statement.
And
Yes.
And on oath, my lord, I am stating. On oath, I am stating. If I am any. Yes, sir. Yes, sir. Only grievance, man.
Video telephone. despite making a request. Despite making a request. Despite making a request.
Request on 21st March.
You have acknowledged that. Mr. Rudra, you have acknowledged.
No, when he made the request, I'm saying that.
Assessment order.
Twenty-ninth
March 2000.
Difficult for you also. It's very difficult. 29 March 2024. Yes, here.
22-23, my lord. My lord. Serial number 4, my lord. Page 18.
Of the assessment.
Tata Scrutiny.
A screenshot. And he had probably picked out a screenshot.
Yes, madam. Total.
Online total. Request for BC had been made. Video conferencing had been made. The link, the video link under the corresponding the details under the corresponding entry are absent. Under the corresponding entry, yes.
Yes, madam.
Nature of regards, petition. Nature of regards so this is very good.
As your lordship. Well, only thing if they take the because no assessment order passed in 29th March.
That the writ petition is pending, not to take.
Then if the learned friend is saying, my lord.
I will take.
If my learned friend said, then
They would be knowing that the writ petition is pending.
Not personally, but
well, the only thing in the meantime, no coercive measure, my lord.
I can't say anything.
cannot, he cannot yet say that you would not.
The only thing my lord can try, no coercive measure can be taken. I'm not from very specific stay.
Or essentially is.
But it is apparent, madam. This is not. It is apparent. Yes, sir.
Hi.
Then one next week, my lord. Any day next week, my lord. Well, 11th of. Well, in the month list, my lord, difficult, my lord.
Sir, monthly list তো চলছে। Monthly list তো চলছে।
Oh, so is my lord. Then.
Accepting next week. Next week, I will take up
Acha, that's fine. Grateful, man.
But I am for the petition. But I am challenging an order of adjudication on the ground of jurisdiction. I am saying that the person who has passed the order has no jurisdiction. Because the order has been passed by the superintendent of CGST, the circular providing the monetary limitation to the adjudicating authority provides that superintendent cannot decide anything where the tax demand is more than rupees 10 lakh. Here, he has demanded 18 lakh. So it is beyond his jurisdiction. No, order. This is order. My lord, the circular, this is at page 72. My lord will kindly directly come to page 74. Kindly see the first entry, Superintendent of Central Tax. Now kindly see the third column, monetary limit of the amount of central tax, including says not paid or short paid or erroneously refunded or input tax credit of central tax wrongly availed or utilized for issuance of show cause notice and passing of order under section 73 and 74. That will be not exceeding rupees 10 lakh. When there is only central tax. Now, if it goes to central tax plus state tax, then the next column, 20 lakh. If it goes to central tax, sales tax and IGST, 20 lakh. Now, in my case, it is only central tax.
Instructions? I'll take instructions. Other.
No, there is another point. My lord, the order has been passed in 2023 under section 73 for a period of 2017-18, whereas their limitation is 3 years. Now, this limitation, can you allow me? Extended period is section 74. My lord, here different provisions has been given in GST 73 and 74. He has that is 74.
That is 74.
He has done it under 73. No extended period. He has taken recourse to a notification. Kindly come to page 79. No, this also. Well, allow me 30 seconds. Yes. He has relied on a notification that is at page 79. On the basis of this notification, whatever proceeding has been initiated has been stayed by this honorable court. So if we realize both, because I am challenging virus of this notification also. Kindly see this judgment. Kindly see this for once. Over here, my lord will find the challenge was in the writ petition on an adjudication order dated 30th November 2023. My lord will find it was also under section 73. Then my lord will find.
My lord has also passed the order. Stay.
Okay.
My lord has also passed.
Okay, that I am not aware of. I am thankful to my learned friend.
That building. Your lordship is sitting that building.
Well, when the urgent matters, my lord.
Urgent matters taken up, your lordship has passed.
So in any event, this matter will be, in this case, I will be referring to this judgment for stay of the input order.
Get out the matter. See on affidavits, Mr. Chakravarti, I don't know where it is. Can be disposed of at no such state.
Disposed of and remand back.
Actually,
if remand back, then also this question will remain.
First point.
Then the second point.
Second point I'll consider.
Right.
At that stage.
Right.
At that stage. But if you want to only a stay, I will not grant.
No, I am not asking for stay. I want disposal. No, I want disposal.
I do not know.
I want disposal because both are in my favor. Why should I? Disposal.
We are under 112. Ordinarily, I am at. I am bound to hear this.
Yes.
I can't dispose of them and say, no, I will dispose it of them.
Why I was saying, because on this issue,
After the vacation. This cannot be any urgency. You can't have any urgency.
No, I have.
You have. You have to this code.
But but there are 5 measures they can take on any morning. On any morning, they can attach my bank account. They can attach my property. They can stop my ITC. 5 measures they have. If they do it, then I will come and I will run.
Monday.
Yes. The superintendent.
Yeah.
Adjudicating authority in this case.
But also, German livelihood.
He cannot be, because up to 10 lakh is his jurisdiction. He determined 18 lakh. बोला दो. This should have been done by AC.
Superintendent central tax has jurisdiction pass an order
Involving CGST.
involving CGST to the extent of state tax and refund. So it's
18 lakh, more than 18 lakh.
Because how many in excess of the state
10 lakhs.
concern and to authority. What are we doing? The meaning of service tax act 87. And as such, the order passed by the
That is one number 5.
respond number 5. Tuesday I'm keeping it because you have a division range next week. Next week is the last week.
Yes, yes, Monday, Monday.
Monday, kindly keep it on Monday.
And next week I will be only taking up urgent issues.
Or my lord can keep it after vacation, subject to no recovery action on the basis of this order.
And this is after the vacation.
No, on this notification, which are they? Another High Court. Unreported. Yeah, Allahabad High Court, unreported.
March 2020.
Kindly come to page 81, my lord. The confusion is because of the date 81 is after 79. The continuation. 81 is the continuation of 79. I have no.
Your lordship has passed.
তোমার কোন ম্যাটারে মাইলর অর্ডার দিয়েছিল এক্সটেনশনের উপরে স্টেটার আরে এক্সটেনশন অফ 73
We will leave the full number.
My lord, Mahmood associate Mr. Ghosh was appearing before your lordship.
But Mahmood has been on the, there's a show cause notice was state.
Yes.
Yes, madam, I have handed over on the item number 94. I have handed over.
94 file. তুমি এইমাত্র পড়ে গেছো আবার একটা সেম ম্যাটার
এখন সেইটাই করছে
Madam, I will give me 2-3 minutes from library.
কি সিরিয়াল নাম্বার
94
আজকেই 94 নাম্বারটা ছিল
পুলিশ যে জাজমেন্ট দিয়েছিল না নাম্বার কি আমরা বার করে নেবো
ওকে
আচ্ছা
WPA number 4095 of 2024.
4095
4095 or 24
WPA.
Mahmood
Associates Privately.
WhatsApp করো আজকেই তো সব
Said that.
ঠিক আসেনি
কি হলো কালি আসছে না না তো একটা অ্যাপ্লিকেশন করে রাখ না এটা ফর্ম সেকশন এটা ফর্ম সেকশন
Show cause. Show cause is not there. In my case, writ petition show cause is not. Order is at page 65.
So the
Dated is at the top, 30th December 2023. Amount is at the bottom, CGST 18,87,727. And the procedure code is uploaded in 30 this is given on, this is issued on 30th December 2023. Right hand side top.
Of the order sheet is different date.
This is the next page. That is the details of the order. He issued details of the order on 4th December, but he issued the summary of order along with the details of the order on 23rd of December. Show cause notice was issued, my lord. Kindly come to page 68 at the top on 10th March 2023. नहीं है मतलब नहीं बेटा फाइन हमें ये पॉइंट में लिखी नहीं चलो फाइन कौन सा फाइन नोटिस हो पाएंगे चलो भाई Final.
my lord.
This is the remand. Page 65 last. Page 65 is last entry. Detail of demand. Then where your lordship has recorded order dated 30th December 2023. Will it be your lordship? Demand. Will it be your lordship's pleasure to record as appearing at annexure P5 because of the two dates, 30 December and 4th December?
December, there is no prayer.
4th December.
In your writ petition,
Oh, yeah, 30 December, 4th December, both dates are there.
there is no prayer in your writ petition on 30th.
My prayer is on 4th December.
On 4th December.
See, I was also writing because it was recorded
4th December.
That's why annexure P5 will clear the situation. Deeply
June. June.
But the affidavit in opposite service.
Service.
List.
Tomorrow Friday, your lordship will application or
No, motion because of the vacation. Then we follow the list. Tomorrow. So tomorrow we will mention the urgent matters for the hearing in the next month, next week. Oh, extremely urgent only. One matter I will mention. Only
not the mention.
tomorrow.
You come on tomorrow.
Deeply obliged.
It is a difficult matter.
Yes, I have always had.
99.
Today, advocate is out of station, so kindly next matter.
Today, my lord, advocate is out of station, so next.
Hundred.
But I am appealing for respondent number 1 to 5 and 16.
99 নামটা দিয়ে দেবেন আমার।
My lord, I am appealing for respondent number 15 in this matter, item 100.
Yes, my lord, I am for the petitioner now. 99. My lord, it is an urgent matter. If it is lost, petitioner, all the bank account and the property has been freezed by the Monday, my lord, Tuesday. In the last 1 year has been lapsed, lordship. My lord, actually my case is that
I will take up your matter. I will decide your matter. Item number 2.
Yes. And without affidavit, this cannot be decided.
I will hear it. Whether without item number 2.
actually what sir, actually in this matter my counsel is Mr. Pranit Bhai.
Take it up with you. Tell him I'll take up with you. Short time. So I'll take it up with you.
Yes. Very well.
Yes, yes, sir. What is the urgency in the matter?
No.
Respondent.
Very good.
আরে ছেড়ে দাও না আরে মান্থলি লিস্ট অফ জুন আবার ছেড়ে দিতে
Lordship,
No, I will delete it without it.
Lordship, actually what happened, it is a matter of under section 83. The property seized by the respondent. It is expiry after 1 year. The 1 year has been expired and they have again started. So
In consideration your points, I'll take it up after the vacation. Okay. If this matter, let this matter stand at 6,000. Place this matter in the market system.
okay, but নামটা একটু
101.
my lord. My lord, actually, this is a case without issuing any so-called notice, my lord. They are issued only DRC 07.
But I have sought for instructions. Can I come back tomorrow? Not today. Only not today.
And two.
Yes, my lord. Actually, my lord, ASMT 010. Yes, my lord, actually, it was submitted on page 10, dated 15/7/2022. That is the scrutiny of demand. Your petitioner has received it and ASMT 11 has also been submitted. And the actual amount what is due, that was also paid. There is no discrepancy at all. Before this ASMT 10 issued, that particular amount has already been paid in the year 2019. Well,
ASMT 10 is the discrepancy which is identified.
Yes.
In terms of section 61.
Yes. Yes, my lord.
So after receipt of that, you submitted ASMT
11 and the amount which was detected automatically, that has been paid earlier.
Now what happened there?
Then DRC 07, my lord,
Order was passed, yes.
ASM issued or order.
Order was passed thereafter.
Yes, actually, DRC 07 was paid by your petitioner. That is the actual amount of due amount. Prior.
Praying today, what is your prayer?
Yes, my lord. Actually, my prayer, after that, the interest amount was detected and it was issued. DRC 07, my lord. Please, page number 33.
So you preferred an appeal thereafter.
Yes, I preferred an app.
That's what are you aggrieved by?
Yes, actually, the actual amount which was due in interest amount, actually, that was collected without giving any opportunity, my lord. Actually, when the appeal was filed, APL 02 was taken by the appellate authority. On that particular day, the appeal was also rejected. That is APL 02, my.
On the ground of limitation.
Yes.
On the ground of limitation.
No, my lord.
After 6 months, this appeal was filed.
Yes. Where is the section 5 application?
No, actually.
I take it up tomorrow.
Not this week.
Not this week, my lord. 103, yes.
Very good. Since an accommodation has been sought for order of petitioner, let this matter stand adjourned and appear under the second month of June.
At the list of June will come.
But 102 is not.
102 is not made not today, my lord. Even 101 has been made not.
Yes.
1 to Calcutta. 1 to Calcutta. Yes.
অর্ডার হয়নি তো এটা
এই নামটা লিখে দিন তো।
এটা তো অর্ডার হয়নি অর্ডার তো হয়নি কোনটা 102 তো কোনো অর্ডার হলো না 103 যেটা অর্ডার করে 103 ও 103 একটা অর্ডার সাইড লিখে দাও তো অর্ডিনারি সাইড ম্যাটার এক্সজস্ট হলো অ্যাপ্লিকেট সাইড ম্যাটার হবে সাইড ম্যাটার হতে পারে অ্যাপ্লিকেট সাইড হবে
যদি হয় হবে না অনেকগুলো আছে অনেকগুলো আছে।
চলো 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 লিখছি এখন আমি নিচ্ছি কোথায় গেল
Please call the list.
Original side item number 1.
But yesterday's matter, like reasons to believe. My lord asked me to bring that judgment of Patna High Court where it was held that betel nut is a primary form of goods because they were showing a subsequent destruction order. My lord recorded an order.
আমাদের অফিস দেখাবে কি কিছু দেখাবে
This is the order of the Patna High Court. There is another order from Calcutta, Kerala na Karnataka High Court. Copy করিস নি? না না দেওয়া হয়নি এটার কপি কোথায়?
This is on the food safety.
Well, actually that only.
Yes.
That's the primary form of goods is not for human consumption. Betel nut or erica nut is a primary form of agricultural produce. Well, the same.
You want to destroy it? Yes, sir.
Well, another judgment, Kerala, my learned friend will pardon me. I have no copy, only one copy.
You too.
Only one copy.
The unreported judgment.
No, this is report. Devona, okay, my lord. This is not, copy is not there.
Mr. Bhattacharya,
My lord.
you see
My lord,
very clear.
I,
So
I,
that
I will reply, my lord. I will give reply from the judgment of my lord, my learned friend, Rely number 2021. That will help me also, my lord. Kindly come that judgment, my lord, first. Then I will. Is there any, my lord has.
he is relying on two judgments.
My lord.
The only issue for consideration at this stage,
My lord.
is pending disposal of the parent matter. They have sought for provisional release.
My lord.
I will only direct you to consider and dispose of that.
Yes, yes, that can be, certainly. We agree.
And I will take note of the submissions made by you and the disclosure made by you. And I will give my findings and reasonings on that. That is why I want you to address this court on this issue. Come back on Monday, conclude the matter. And because I have to, I'll deal with your contention.
But by Monday, I think the representation cannot be considered within a short period.
No. I'll dispose of, I'm not disposing of the matter. But I'll pass the reasoned order why. Where is that document of yours?
Destruction order. Yesterday.
Why the destruction order cannot be given effect to at all?
My lord, we have the subsequent correspondences we have received, my lord. My lord, we have sent it, really, it has been sent to the FASI, my lord. And my lord, ultimately on 19th April, my lord,
Then you do disclose all the documents.
Yes.
Whatever you want. Hand over all the copies to Mr. Chakraborty. The piecemeal manner, if it is hard, it's very difficult. So that is what I am saying. I have understood your contention.
My lord, my seizure is otherwise good. Because
I do not know, sir.
2021
And I will
judgment.
test out.
My lord, Nikom Copper, my lord, that will help
I will
me
test
also.
out. I do not know whether it is good, bad, different. That will be considered by this court.
My lord.
But for the time being, you cannot hold on. You see, he has made an application for provisional release. Why will you not decide that?
Certainly. That is so.
You decide the application for provisional release.
My lord. Yes.
And then you come back. It's under 110A.
Yes, 110A.
The statute provides the remedy. He has invoked the remedy.
My lord.
But you are sitting tight over the matter. Ask your authorities to decide it. You can again give a decision very well. I will take into consideration what they have decided. This pendency of the writ application shall not stand in the way of the authorities deciding the application under 100 the application for provisional release.
Yes. Will your lordship record an order to that effect?
No, I am not recording, because if I record that, then you might come back and say that this is not being done. So I will on this question, I will decide it completely. Either you decide it or I'll decide this question and send it back. Monday.
Alright, instead of
one submission.
Instead of Monday, my lord, keep it on Tuesday, my lord.
You're going to the outer limit. After that,
no, Monday,
onwards, I'll not pick up
Monday there is an election, my lord. Monday there is.
Oh, very well, Mr.
My lord, only one submission for my learned friend also, because he will be taking the instruction. My lord has seen that in this particular case, there was seizure of 2 consignments practically. I am fighting for the second one. Yesterday, they have given me this copy of this deportation / destruction order. This only refers to the seizure case number. This does not refer to any drawal of sample. He will disclose it that when the sample has been drawn, whether it is in my presence from my consent. Because this report cannot be.
Then
the legality, validity of the report you will challenge separately, sir.
Correct. No, he is giving me now.
When yesterday, all these issues have cropped up because Mr. Bhattacharya said that even if I decide in your favor, I cannot release it.
Yes.
That is the reason why.
Yes.
He said, I will not give you back the goods.
And sir, I apprehend.
That is the reason why.
You will ask him to pass an order. He will refer to this.
How do you know?
Am I apprehension?
He is not your enemy.
To some extent.
No.
So, but this Consignment is concerned.
No.
Nothing else. Nothing personal with Mr. Bhattacharya.
Not what I no, why the department is also not your enemy. They are inquiring into the matter. They are entitled to in law.
Now,
the order of detention has been issued.
That's what I have challenged.
So then, yes, call the next matter.
My lord, not a hard and adjourn for the my lord.
No, nothing. Tomorrow,
We are not getting anything. My lord.
No, you on the last occasion, everything was recorded.
My lord, first day you lost it not recorded.
No, Monday.
My lord,
On
may I-
Tuesday, list this matter under the same heading on Tuesday. Date diye dao.
And may I take the copy of that? Kerala
Yes,
High Court?
look at the file, whatever the documents you
Kerala
want to
High
take. No, there might be multiple copies. Check it. Take it back.
Item number 2.
My lord, I am appearing for item number 2.
Yes.
Last occasion, my lord had directed the respondent to provide a circular where it says the 20% amount has to be deposited to get the stay.
Yes.
The CVDT circulars.
Lord, I'm handing up.
Yes. देखिए देखो. No.
Lord, but they have only one copy, Lord, because on the last occasion they had brought.
No, she's appearing online, so
Circular.
disclose the particulars so that she can mail.
Yes, that time, Lord, this is instruction, but famous instruction number 1914, dated 21st of March 1996, my lord, which was amended, my lord, on 29th of February 2016. Subsequently, my lord, it was again amended, my lord, to make it 20% from 15% on 31st of July 2017. My lord, the first circular, my lord, which is of 1996, my lord, I am placing only the amended portion of 2016 because that shows, my lord, 15%. If your lordship takes, my lord, clause 4A, capital A. In a case where the outstanding demand is disputed before CITA, the assessing officer shall grant stay of demand till disposal of first appeal on payment of 15% of the disputed demand, unless the case falls in the category discussed in para B here under. My lord, para B is, it will be exceeding, my lord, 15%. We are not concerned with that. My lord, this 15% was subsequently enhanced. Lord, at page 3 of the bunch, your lordship will find, my lord, that 15% stands modified to 20%.
Yes, continue. Yes.
No, my lord, how the stay, the guidelines for staying the demand is, my lord, at page 4.
No, are they asking for stay of the demand?
Yes.
No, my lord, we are not asking for the stay of the demand. We are just saying the amount which they have raised is more than 20%. That should be less than 20% because it is just an office memorandum, my lord. And there is a judgment of Supreme Court which says that is not mandatory. It can be lesser than 20% also. The assessment income was 17 crore and they are demanding 8 crores, my lord.
You have preferred an appeal. You have preferred an appeal.
My lord, we have preferred an appeal against the assessment order, not against the demand order. And the demand order, generally the practice is that we file an stay application. If the stay is rejected, then we file a writ petition. And there are so many judgments where it says, and in the Supreme Court, the
46, madam. Appeal is under section 246.
Has to be.
that is for the 143 order, my lord.
Mr. Rai, I don't know why this is under 220 subsection
yes,
6,
yes,
not to treat in default,
yes, my lord,
not
actually,
the stay.
my lord, it is loosely termed as stay. That is why the circular also.
No, this is stay is in reference to the appellate or the authorities of jurisdiction.
The circular says that you will not say it, not call it stay. You will call it, my lord, not to be treated.
Come to 220 subsection 6. It's very clear.
Yes, yes, it's there. It's there.
As presented in appeal under section 246,
yes,
the assessing officer may, in his discretion, subject to such conditions he may think fit to impose in the circumstance of the case, treat the assessee as not being in default in respect of the amount in dispute. This is the case. So when this is there, madam, how much?
Lord, if lordship, Lord, kindly takes, Lord, page 5 of the bunch, my lord, that I have handed up. Page
yes,
5.
yes.
Just to clarify, my lord. My lord, item 4, IV, my lord.
Yes.
Since the phrase stay of demand does not occur in section 220 subsection 6 of the Income Tax Act, the assessing officer should always use in any order passed under section 220 subsection 6 or under section 223 or under section
So very well. So very well. I get it. So why did he write? Why the entire memorandum proceeds with the word stay? If that is so, and see the consideration in grant.
It is essentially that we will not be, my lord, pressing for the demand. It is
correct, not to treat him in default.
Yes, and the demand is not pressed. That is it for the moment.
Now, what are the guidelines? Instruction of 1993?
Yes, my lord. The guidelines, my lord, your lordship.
1993 is entirely different.
Yes. Guidelines, your lordship will take, my lord, page 4 of the bunch.
Yes, this is the guideline.
Yes, page 4 of the bunch. These are the guidelines. Yes. These are the guidelines, my lord. I understand, my lord, that it is a discretion vested with the assessing officer, which he is to exercise, my lord.
Has he decided this? No.
That is where I was coming, my lord. In fact, my lord, in my very respectful submission, any submission which I make here will be opposing myself itself, my lord, because reasons, my lord, are not happy. My lord, it should.
Where is that? Where is that?
So, lordship takes, my lord, page 49.
Yes.
Page 49, my lord, 50 is. Lord, he should decide it, Lord, with.
Did not decide it.
He has not decided. That is about all. Page 49, 50.
No, 49, kindly come to. Yes, madam. How much part payment have you done?
5 lakh, my lord.
5 lakhs, my lord.
Out of?
8 crore.
Out of 8 crores. My lord may send it back to the assessing officer. He can direct us to pay whatever amount as per the notification, my lord. But this is what he's demanding, like 50% of the demand assessment.
I'll direct you to secure that entire amount, 15%.
20%, my lord, is the.
Where 20% where?
Lord, if your lordship takes, my lord, page 3, the amendment.
Otherwise, the appeal shall not be heard, madam.
Page 3.
And I'll also issue appropriate direction on the appellate authority to dispose of the appeal.
Yes, yes.
So it
Please,
will be.
my lord may pass it in.
To payment, madam. First pay, then the appeal comes.
Page 3, my lord.
Yes.
My lord, second last paragraph. The matter has been reviewed by the board in the light of the feedback received from field functionaries in view of the board's efforts to contain overpitched assessments through several measures resulting in fairer and more reasonable orders. The standard rate of 15% of the disputed demand is found to be on the lower side. Accordingly, it has been decided that the standard rate prescribed in the OM dated 29/2/2016 be revised to 20% of the disputed demand.
My lord, after this, there is a Supreme Court order of 2018 where it says it has to be lesser than 20%. The Supreme Court order I have.
Yes, madam. Hand over.
Page number 14 from the compilation. 1/4.
Compilation or writ petition, madam?
Compilation, my lord. There's a judgment compilation. Page number 1/4, my lord. There's a one-page order.
Yeah, open to him lesser amount. You tell me why lesser amount should be paid in this case. You argue that.
My lord says the lesser amount can be paid. So
Why?
it,
Why? This is some reason
because
justified.
this is not a, this is just a office memorandum. It's a quasi judiciary. But my lord, if
That is a direction before the appellate authority. It is before the appellate authority, not with the assessing officer. The appellate authority, you can also make an application before the assessing authority, get a stay. You have invoked the jurisdiction of this court by saying that the assessing officer did not take into consideration your application in the light of section 20, subsection 6 of the IT Act. That is your case, madam. So therefore, I called for the circulars on the subject. What are the circulars, guidelines? Now, CBDT circulars.
but as per the guideline also, they are asking more. They are asking 50%.
On you, but they are binding on the SSE. Circulars are
Then they have to send a demand notice of 20%, my lord, not 50%. The assessment order is of 18, 17.
no question of demand. You will only deposit.
Will be
of the sets.
Whatever my lord give direction will be depositing on, my lord may send back to the assessing officer. They can revise the demand because the demand is in higher side.
Officer,
I'm not able to hear you properly, my lord.
why do you want the matter to be sent back to the assessing officer?
Because they have raised a higher demand, my lord.
Right, whatever demand they have raised. And there cannot be any demand. Very well. If any demand is there, I will provide that such demand shall not be enforced. But are you ready and willing? Take instruction.
I will take instruction then, my lord. My lord may call it on Monday. I'll take instruction.
I'm not going to send this back, madam, on this issue.
Please, my lord. So my lord me asking me
Madam, your only issue is whether you should be treated to be not in default pending disposal of the appeal.
So 20% the instruction I have to take, right?
Actually, take instructions on 20%.
Please, I'll take the instruction. I'll take the instruction. My lord, and put it on Monday.
If you want to take instruction, you take. Otherwise, on Monday, I'll pass an order and direct.
Monday, I'll be present, my lord. I'll take with the instruction. I'll be present.
Madam, means I'll not give you time till the end of the month to pay. You have to put in.
No. Monday, I'll take the instruction and come back.
So shouldn't be difficult. You've already got from 9th of May. Matter was first moved on 9th.
I will take instruction and come back on Monday.
So, Mr. Rai, maximum
20% of 8 lakh. 8 crore.
8 crore. So it's around
16 lakh something. 1 crore 60 lakh.
1 crore 60 lakhs maximum. If they put in 1 crore 50 lakhs, that will do. Round figure.
Okay.
Let them come up with a round figure.
I'll take instruction and come back on Monday.
And I'll also direct the appeal to be disposed of already.
Please, my lord. My lord may pass a time-bound order.
Actually, so.
Please.
Item number 3. For the petitioner, I'm being led by Mr. Mona Post. I'm being led by Mr. Mona Post. With your lordship's permission, I may.
Yes, naturally. Same issue involved that. Yes.
Service, if I may.
Seen the judgment?
I've seen the judgment. Well, there is a distinction, and
show me. Argue it.
In my humble submission, the judgment will not apply in the instant case. The
Sure.
reasons are, my lord, the reasons
Yes,
are.
yes. Since his senior is not there, you place it, sir. Yes, yes.
Your lordship, kindly appreciate who has filed the petition. The petition has been filed by a person who has no.
First of all, let us one by one. First of all, take me to the order.
Yes.
Detention order.
I tell you, lordship, what has happened. My lord, on 2/2/2024, the seizure was carried out.
Yes. Yes.
The invocation of jurisdiction.
Where, which page? Which page?
I will show to your lordship. Lordship, the seizure list is at page 15 and page 16.
Yes.
The said
Just
person.
a minute, just a minute. Page 15. Yes. Very well. From where? From where?
I tell you, lordship, the persons were intercepted, detained at a place near Boshihat. I will show to your lordship from the record. From the record, it will appear. I have the Panchnama with myself.
Show me the Panchnama.
Yes, ma'am.
This is the seizure list. Inventory comes seizure list.
Inventory comes seizure list, but the initial action started at Boshihat, at a place near Boshihat.
Is there any detention order?
I tell you, lordship, my lord, Panchnama has been done. In the Panchnama, the whole entire proceeding is recorded, where it started, and how it culminated.
Yes. Manoj Mondol. Very well.
Lordship, kindly comes to the first para.
Yes.
কিছু বলেছি তাহলে
No, we have not received a copy of the Kachna.
Where is this bridge?
It is near Boshihat.
Where do I get
Haroa
it?
Bridge. Haroa Bridge.
Oh, achha, yeah, Haroa.
Not Haroa, my lord, Haroa.
Yes, Haroa Bridge.
At 24 Pargona.
Haroa.
24 Pargona North.
যেটা বলছি সেটা আমার উত্তরটা দাও না
Ajay, give Mr. Bose a copy of the Panchnama.
মানে দি
I'll hear you, Mr. Bose. Wait,
Hello,
wait. Later. Yes. So he was taken into, he was detained.
He was intercepted.
He
was intercepted. The fact of carrying of illicit gold was disclosed at that point of time. He was detained.
Where? Which place?
At Haroa, at Boshihat, near Boshihat.
Just a
planned
minute.
at
Just a
about
minute.
12:05 p.m. on 2/2/24.
Just a minute. Just a minute.
Second
sir.
paragraph.
Inspector of Customs, DPO Customs. Very well. Second paragraph.
As planned, at about 12:05 p.m. on 2/2/24, one person reached near a pawn shop in Haroa Bazaar, who was identified by the informer, who was immediately apprehended by the custom officers. The officers then asked whether he was carrying any smuggled gold. Firstly, he denied, but after insisting, he accepted that he was carrying smuggled gold, and he himself tendered the gold to the officers. So the golds were handed over to the officers at Haroa. Immediately, the officers make him sit in.
So the action is in Haroa.
Action started at Haroa, and the invocation of jurisdiction was at Haroa.
And this list is by this Panchnama has been prepared
This
by.
Panchnama has been prepared by the officers who were involved in the said seizures by the seizing.
Superintendent of Customs. P means preventive.
Preventive.
Very well. And this is also by preventive.
Yes, madam.
It's a memorandum of arrest.
Jurisdiction all over West Bengal.
That is different. Now, where is that notification?
Yes.
কপি দাও জজ সাহেবকে
They have annexed the copy of the notification. No.
No, notification has not been annexed.
No, madam, not has.
Very
Wow. The matter is based on notification and তুমি notification খুঁজছো
Hand over a copy of the notification.
Yes, ma'am.
My lord, if your lordship can take some copy.
Oh, I'll give you lordship 2 copies of.
It is marked, lordship, can you excuse me for
I have the marked copy.
Lordship, kindly sees the red mark. The jurisdiction of the
Then I'm 11. That is 11. And
10 is for port and airport, and 11 is for preventive.
No, port, airport. And there's one more thing, downstream.
Your lordship has considered it.
Downstream. So here it is not there. The case was directly under the complex, airport complex.
Yes.
And
Domestic terminal, airport complex.
Airport, yes, domestic terminal, airport complex. So it was clearly, jurisdiction was clearly defined there.
Even here.
Here it is.
Kindly take page 15.
Yes, I'm on page 15.
But the cloud which has been sought to be created, I'll clear the cloud.
Naturally, sir, you are there.
I appreciate.
Yes, sir.
Kindly take page 15. The answer is here. Well, kindly take the date and time of detection of goods. 2nd Feb 2024, 11:55 a.m. Has your lordship found that? Well, kindly come to the column below that. Date and time of seizure of goods. 2nd February, 11:05 p.m. So, my lord, there's a gulf of difference between detention and seizure. Now, my lord, your lordship. My lord.
Detention and seizure is different.
Different. Now I'll tell you, lordship, why I say this. Well, now, kindly come to the next column.
Yes.
Place of recovery stroke interception. Hardware is there, my lord. Your lordship will see. I need not place the entire address.
Yes.
Serial number 4. Now take place of seizure. Office of Barashat Custom Division, 4th floor, MS Building, 15/1 Strand Road, Customs House, Kolkata 1. This is the place of seizure. You may have detained in London, doesn't matter. Your place of seizure gives you jurisdiction. Now, my lord, your lordship will take your lordships the notification once.
Yes.
The table. Oh God. Your lordship has extensively dealt with this in the earlier judgment of your lordship. But kindly come to where the designation of officer and area is defined. Well, kindly come
your
to serial number 10.
Understood correctly, Mr. Bose. Your contention is that the place of seizure is the place where the initiation of proceedings under section 110 starts. একবার একটা বইটা দাও তো ওখান থেকে এই ওই পাশে কাস্টমস একটা
My lord, before your lordship
না ছোট
comes
বই
to
এসছে ছোট বই এসছে তো না ওটাই দাও ও পাশে তো just a minute sir
I just wish to
I'm
draw your
not so
lordship
fast.
attention. No,
Sir,
I
just
just
wait
wish
sir
to draw.
let me go through this once and then
Yeah. Well, kindly take some of the provisions which I wish to rely upon. Well, first,
but
kindly
first
take.
let me go through section 110 once and
Well, before that, kindly take 100. 100.
Yes. Very
Well, this is under chapter 13, search, seizure and arrest. Because since your lordship likes to read it on your lordship's.
Very well.
Then, my lord, first is search. Then, my lord, kindly see. Power to search suspected. Both are reasons to believe. Now, my lord, kindly take subsection 2. This is gold. This is gold. So, my lord, kindly take subsection 2 of section 101. Goods referred to in subsection 1 are the following. Then this is what will apply. Gold, diamond manufacturers. Then, my lord, kindly take sub 102. Where an officer of custom is about to search any person under the provisions of section 100 or 101, the officer of custom shall, if such person so requires, take him without unnecessary delay to the nearest gazetted officer of customs or magistrate. Then, my lord, kindly take subsection 4 once. Before making a search under the provisions of 100 or 101, the officer of customs shall call upon 2 or more persons to attend the witness and search and may issue, my lord, kindly see, may issue an order in writing to them or any of them so to do, and search shall be made in the presence of such persons, and list of things seized in the course of such seizure shall be prepared by such officer another person and signed by such witnesses. Well, this is that panchnama. They are called panchas. These witnesses are called panchas. Well, anyway, that's a different issue. Well, they are required to be respectable persons of the society. None of them are. Be that as it may. Now, my lord, once you're invoking the jurisdiction of seizing, well, then you immediately come to 101, my lord.
For search.
Yes, that's what I said. Then comes seizure.
No,
So
let
what
us
I am saying
understand-
is,
let us understand in the
my lord,
in the light of the facts.
my lord.
There is no search here.
Yes, my lord.
There is interception.
Search me. They find gold.
Come
They
to the
take me to,
panchnama.
yes, my lord. Panchnama is a recording by the officer. I am not given copy, so your lordship, my lord, my respectful submission is that they cannot rely upon the
Cannot
panchnama.
ignore this. This is a document. After all, at the end of the writ proceedings, I cannot ignore this.
No.
You have to, difficulties, Mr.
My
Bose, you have to respond in the other matter also.
Yes.
You have to respond by accepting whatever is there, because otherwise disputed questions of fact, I cannot enter into.
No, my lord.
So panchnama, you cannot really say that I cannot go into this. This is a
No,
document.
I am not saying
This is
that.
a record they are relying on. And
Correct.
this, as a court exercising jurisdiction and writ in the nature of Shashirai, I am bound to take into consideration this document.
Absolutely.
So show me what is their case made out here, Panchnama.
Now, my lord, kindly take.
It's a contemporaneous document.
Yes, my lord, kindly take the last sentence in the first paragraph.
Yes.
Passed through Harwa Bridge at around 11:30, carrying
Yes.
smuggled gold with him, who would apprehend on arrival, such and such. Then, my lord, I'm not even looking into that means justify the end. That part I'm not even ignoring for the time being. As planned at 11:30, such and such, one officer took the key. So basically, this is the interception. Interception happens at 11:30. As recorded in the seizure order, then what happens?
Then he
Then, my lord,
tenders the gold.
and 3 p.m. took the bike. Then, my lord, kindly take the third paragraph. At 3 p.m.
No. In
My
second paragraph only.
Yes,
He
my lord.
tenders the gold.
Yes.
There is no search. So
Yes,
104 does
everything-
not apply. That's why I've said
everything-
104 does not apply. 104, 100, not 100, 102 perhaps. Just a minute.
102 subsection 4.
So yes, 102(4) does not apply.
No,
There
what
was no search. It was a tender. I have to accept their case, whatever the case have
Yes.
made out.
Even if your lordship considers it's a tender,
I will still take your argument,
Intercept.
Mr. Bose. Your argument is that where it is actually seized is the place where you have, where the person who's seizing has to have jurisdiction. That is your primary argument.
and that's that yes, of course, primary argument. And my lord, that this argument is substantiated with the document at page 15. The seizure order records it that the officer who has exercised his jurisdiction is the officer, preventive officer, having his office at Strand Road. That is the jurisdiction he is exercising. So, my lord, today when your lordship is exercising ordinary original jurisdiction of the High Court at Calcutta,
No, extraordinary.
mane ordinary original civil jurisdiction. Well, extraordinary will take your lordship to contempt.
No, this is the extraordinary jurisdiction.
No, I am not on say. I was giving a hypothetical example of the original side.
I see.
That the territorial part. So that is why, but that's the concept of the suit for land. Territorial. Where?
Cause of action.
My lord.
The cause of action, where the cause of action arises.
My lord, here, my lord, the cause of action arises when you seize.
That
I am
is what
telling.
you're trying to say.
Correct. I say that.
I understand that. That you're trying to say where the cause of action arises. Now,
Because-
let us come to section 110 once.
Yes, my lord. My lord, before your lordship kindly takes a few more sentences from the Panchnama.
So according to you,
Yes.
let us understand things correctly. According to you,
Yes.
the apprehension was not without jurisdiction, though the seizure was.
Yes. No, apprehension, my lord, is
Was not without jurisdiction, could not have been.
Correct.
Because it is within the state of West Bengal
Yes.
by the preventive.
Yes.
So he had the jurisdiction.
Yes.
But the seizure is their registered office.
Customs house.
Head office, Lordship.
Yes,
Customs house.
downstream,
Customs house.
all
That's
that
what
10
page 50.
kilometers of the watermark. So therefore, it's within the special jurisdiction of the Principal Commissioner of Customs.
100 meters. Standard is 100 meters.
So within this
Yes,
special
within.
jurisdiction. So
Or
therefore,
preventive.
the seizure was without jurisdiction, though the initial action was not.
Initial action is not contemplated under the circular.
Correct. That is different. That's why I want to go to the section and find out.
Correct. Because it is the subordinate officers who does interception. This interception search is by subordinate officers.
Under the jurisdiction control of the Principal Commissioner and of the jurisdictional additional commissioners.
Absolutely.
Let us see.
And my lord, if your lordship will kindly take the Panchnama.
I'll go to the Panchnama. Wait,
Yes.
let me once go through the section.
My lord.
The proper reasons to be provided there no practical. So you agreed with the part of the process which includes seizure of goods.
Correct. I say it is without jurisdiction. So it's a nullity. The seizure order is a nullity. Like your lordship has held in the case of Bhola.
That was a slightly different case.
No, my lord, if your
It was
lordship
very
will see,
clear. The
effectively
line
the
was very
ratio-
clearly demarcated.
My lord,
There it was clearly within the airport domestic terminal. Here it is little different. Factually little different.
my lord, even then, my lord, the exercise of jurisdiction issue remains the same. So if I apply the proposition
There are
of the
two ways
division,
of looking at it, Mr. Choudhury. You see, first, primarily what I can do is I can decide it on the basis of documents on record. Whatever is there. And the Panchnama you have disclosed. Or else I can call for affidavits. Now, if I call for affidavits, I do not know how it will help you. Because I'm not going to grant any stay.
no, I'll tell you, lordship, why. I'll tell you. Kindly give that
I
document.
can't grant any stay.
Kindly give that. What they have done. My lord, this is really interesting. My lord, during the pendency of the writ petition, they give a notice under section 150 for sale of the gold. How could they do it?
You ask for provisional release. No.
No, provisional release. I have asked for unconditional release. So they are selling. They have given me a notice to sell.
Whenever a goods
Gold.
is under section 110, the immediate remedy lies is for making an application for provision release under section 110A, which they have not done.
Well, kindly
Because
see the
they have
date.
They have to establish their ownership over the goods.
You apply under 110 provisional release.
The question is, my lord, if I can prove or if I can satisfy your lordship that the seizure is without jurisdiction. The question of apply. Now, whether I apply for provisional release or not, it's up to me. But you cannot, the custom cannot proceed to sell gold. If it is held to be bad in law, they will sell my gold. Where is the authority in law? Well, kindly set section 151. This notice is wholly without authority and jurisdiction.
I will challenge this notice also.
Well, this came after filing of the writ petition.
Then you have to bring this on record.
Yes, I will. Well, kindly, your lordship can take judicial notice of this.
I'm going to look into this, but he has to take instructions.
Well, I just wish to draw your lordship. When can section 150 be invoked? Kindly have a look at that. Kindly consider that.
Then he will come up and say whether it's been confiscated or not.
No, confiscation is the final result. Confiscation is the final result, even if they succeed, so cause adjudication, then confiscation. Now, where any goods not been confiscated good are to be sold under any of the provisions of there, they shall, after notice to the owner, be sold by public auction or by, now to the owner. My lord, kindly have a look at the language. Notice to the owner. Kindly see who has the notice been issued to. The persons who are carrying the gold. And I have already applied to them, claiming the gold as owners.
That has to be established that he is the owner of the gold.
So then do
Merely
not
by saying
sell
so,
it.
you should not
Where is the authority in law to sell it? You cannot sell. This is not a perishable goods. This is gold.
Smuggled gold, lordship.
That's what you allege. And we have reasons to believe, I have sufficient reasons to prove that ex specie it is not smuggled gold.
Section
I have
123
purchased
puts a burden
domestic
upon him.
purchase, domestic
Section
purchase.
123 puts a burden upon him to establish
I
that the
have.
goods are not smuggled
What is
goods.
the quantity?
Once the goods are seized, quantity is 2.5 kg almost.
I am a manufacturer and seller of gold jewelry.
They are relying upon
What
it.
documents have you disclosed in the petition
My lord, kindly
as
take.
regards your ownership?
Yes, yes. Ownership documents, your lordship will find. If your lordship will see, page 39 to 64. Everything I have disclosed. Tax invoice, challan, everything. Page 39 to 64. It starts, the document starts from, I'll show your lordship the exact document. My lord, I stand corrected, my lord. Page, the bhul likhiyecho keno? Page 14, my lord, kindly have a look at page 14. 1-4.
This is in New Delhi.
My lord, tax invoice, page 14.
New
1-4.
Delhi.
My lord,
You can
yes,
see
yes,
the
yes,
mode
yes.
of, mode of
Yes.
payment. There is no mode of payment.
No
There
mode
is
of
no
payment.
inscriptions. There are no details of the gold. Nothing is there. It's a sham document.
Really, and I'm really surprised. One look and Mr. Day knows it's a sham document.
No, you see, there are certain things like what is the
GST paid, everything paid.
what is the price for that particular day has not been included.
Nothing mentioned.
Yes, my lord, it is there, my lord. 625, 6260. Kindly see. 6262.60.
What is the it's a gold bar, only gold bar.
Yes.
And
Carrots?
what we seized was cut pieces and small pieces. And
These are in bars. Like we buy from the
15
authorized
pieces.
dealers also.
We have seized 15 pieces. In their representation, they claim for 10 pieces. Even what we have seized, that is not telling with their own representation.
This is 24 carat or 22 carat what? Whatever.
My lord, the purity we have tested, it is almost about 99.98.
Nothing is written here. This is the only document of your ownership.
No, well, I have got multiple documents. This is the document which is there a part of the writ petition. Well, I am challenging the seizure order now. If your lordship will show, my lord,
show your best document when you come
well,
forward.
this is the document on record, the tax invoice. Now, my lord, we naturally did not contemplate that, my lord, this situation will come. We are telling in the seizure on the ground of jurisdiction. My lord, if your lordship wants, I can produce all the documents.
No,
but
no,
I am on.
is necessary. No further document. This is sufficient proof.
No, my lord, what I am trying to say is that even if I can prove or not prove, I have come forward under 120.
1,50,00,000 something. Mode of payment is nothing has been mentioned as to what is the mode of payment. 1,50,00,000
page
is the bill amount at page 14. How they have made the payment, nothing has been disclosed. They have disclosed only 2 challans subsequently from the date of seizure, where
page
they have paid over
59,
40 lakhs.
page
So they have paid
59,
gold-
page 60.
Gold of 1,50,00,000, only making a payment of 40 lakhs. Is it believable, lordship? I asked to myself with deepest humility.
Yeah, I did not follow last point. Yes.
The bill amount is 1,50,00,000.
Yes.
They have annexed with this petition 2 bills of payment, which shows 40 lakhs only.
Only?
That was, yes. And those payments have been made subsequent to the date of seizure.
Where is that?
9th of February 2024.
Page number. If your lordship kindly comes to page number 59 and 60. Kindly see the date, lordship, 9 February 2024 on the top. 20 lakhs. Even there is no mention about the bill and other things in respect of which they are making the payment.
Which page, sir?
Lordship kindly comes to page 59 once. 59.
This is 9th of February.
9th of February and seizure, lordship. Kindly appreciate the seizure has taken place on 2nd of February. So the date is anterior. The date is later than the date of seizure.
Well, in commercial law, Mane,
Lordship kindly appreciate a
food
gold
sold
of-
till even nobody is ever paid.
Gold worth rupees 1 lakh, 1 crore 50 lakhs will be paid without making any payment. And moreover, in the said bill, there nothing has been disclosed as to what is the modus of payment, what is the mode of payment. There is no inscription as to the gold bars number and others. Even if Lordship assuming that this bill is not a sham bill, this is a correct bill, then also there is no element of correlation of this amount of gold.
Let us not
with the
go
gold
that
amount
far.
of gold that has been seized.
Let us not go that far whether this is sham or not. But whether this document establishes their ownership or not, that is the only question in respect of the goods which
I humbly
were
submit-
seized. Yes,
I
let
humbly
us.
submit it doesn't
Yes,
establish.
that. Because to establish, to make a claim that this is sham, totally sham, then you have to establish so many things.
No,
That's
we
all.
have issued summons to these Bansal ornaments.
They have done
Bansal
that.
ornaments have refused to come. They have refused to come.
Copy of the summons?
Lordship kindly gives you minutes.
Yes.
May I just say this? Till the time the instruction comes, well, if your lordship will see under section 120, I have come forward.
And we have carried out further investigation in respect of the persons from whose seizure was carried out. We have come to know that those persons are not at all related to the person.
Very well.
petitioner.
That is on factual aspect. I've heard factual aspect enough. You give me that. But the
I have come
legal
forward.
question is, there is another aspect. That is a legal question.
Jurisdiction part.
Now, you have said that you have I'm collating what both of you have said. His submissions is very clear. His submission is the place of the seizure. In the place of the seizure, the person who is seizing must have jurisdiction. And your contention, if I have understood correctly, is that the seizure started, not the seizure, the proceeding started at Horowa Bridge.
Gold was handed over to the officers at Howrah.
And the gold was tendered.
At that place at Bochia.
So custody of the gold was taken at that place.
At that place. Only the culmination of the formality was drawn up at my office at Stand Road.
Isn't that sufficient? The judge signs the order at Calcutta High Court. Sufficient. He went to Jalpaiguri, gave dictation, but signed it here. Does it become an order of Jalpaiguri jurisdiction?
It will stand
I'm just
vitiated.
giving a
It will
hypothetical example.
Stand vitiated. Will that stand vitiated?
No,
because he has signed
no,
it in
vitiated
favor.
now. I am saying, so can he say that no, this is not of the
No,
jurisdiction of
I
Calcutta
think he
High
has
Court?
made a-
It's a Jalpaiguri jurisdiction.
By making a comment, he made it difficult for him.
Well, I'll just tell you, Lordship, that his argument is as absurd as well as asking for the divorce of the neighbor's wife. It's as absurd as that.
Same
Your
applies to my
Caesar,
learned friend also.
Caesar order says Stand Road.
Because the invocation, initiation.
Any judgments you wish to rely?
My lord.
Any judgments you wish to rely?
Well, your lordship's judgment and the
That
division
is on
bench
the
judgment.
issue. There was no dispute where the jurisdiction was on the
No, my lord.
exact place where the goods are seized.
Your lordship says that Caesar.
Not me. It is you who says
Yes,
this.
I say that where it is seized,
The
that
officer
is
who is
the
seizing it should have
correct.
the
My-
jurisdiction to seize it.
Absolutely.
And whether the initiation of proceedings is outside that place, whether this person who completes the formalities according to your learned friend
Understood.
will have the jurisdiction. Any judgments on this?
No. I'll kindly give me time till Monday or Tuesday.
Lordship, in the meantime, Lordship kindly allows us to file an affidavit. We shall come back within a short period of time.
Then let him not sell the gold under. He's given me notice under 150. He cannot
There is
sell the
nothing.
gold.
You did not bring anything on record.
Well, I bring.
Yes, here is the application.
No.
An
They during the pendency of the
Take out an
petition.
application, original side matter. No one prevents you from taking out
No,
an
I know that. But your lordship will kindly
I'm not
appreciate.
taking note of that today. You bring an application, file an application, come back.
এই যে 150
Because
কথা বলা আছে
there is some difficulty. Otherwise, I would have decided.
সাপ্লিমেন্টারি করে ফাট করে দিয়ে দিলে হয়ে যেত ঠিক আছে I'll come back keep lordship if your lordship keeps it on Tuesday
Or if I conclude it, I conclude it now.
Conclude. Then I have to satisfy your lordship on that.
Yes, I think I've heard you, so conclude it.
No, my lord, that your lordship wanted a authority on the point
Can't
that
give
where
me what, then I'll decide it. If you can give me an authority on this, Mr. Bose, this question was always open to you. In the conference, you must have faced this. You must have decided on this.
because
Don't tell me that
your lordship will see
you are for the
is
first time you are
indicated,
considering
the
this.
place of seizure is indicated, the address is given after that.
Panchnama, your client must have known what the Panchnama is.
So, but the Panchnama was not given to us, though it was a.
He is not.
Your
the
gold
person
has
from
been
whose seizure was
seized,
carried
Mr.
out.
Bose. Your gold has been seized. You know where your shoe pinch is.
Of course I do. Of course I do.
Paragraph where it has been very clearly held that copy of the inventory was handed over to the
Kindly
person.
keep it on Tuesday, my lord. I'll come that the
No,
place of
Tuesday is the
seizure
difficult-
is the place.
If Tuesday I have to dictate, then I'll take 2 days to correct it and we'll go too
Then
close
keep it
to
on
the-
Monday, my lord. Keep it on
No,
Monday.
no, I'll finish it here. You
Well,
conclude yourself. You made your point.
Yes, I did. I did. This is my
Anything
point.
else? Anything else? You want
But
to add?
nothing else. I'm relying upon your lordship's judgment, as also, of course, the division bench judgment relied upon by your lordship, on the basis of which that this is jurisdiction. Where you seize is the jurisdiction. And you have seized at Strand Road. So preventive does not have jurisdiction to seize goods from Strand Road. Inherent lack of jurisdiction. So the entire proceeding is a nullity.
Very well. Then I think very well. Let me consider. The present writ application.
May I take your lordship's leave, my lord?
Yes. The present writ application has been filed inter alia challenging the notice, like is challenging the order. This what is challenge? Challenging the seizure dated seizure effected under section 110 of the Customs Act 1962. Vide inventory of goods seized under section vide inventory of goods seized under section 110 of the said act. Vide inventory of goods seized under section 100 said act dated. What is it? What is the date of this notice?
2/2/24.
2nd February 2024. Postal. The petitioner contends that the seizure notice that the seizure has been effected by the Superintendent of Customs within bracket P, DPU Barashat Customs Division, Kolkata 7,01,000 at Stand Road
At Custom House Stand Road.
At Customs House Stand Road. Full stop. According to the petitioner, the concerned officer who had seized the goods did not have the jurisdiction to effect such seizure as the Customs House at Stand Road did not fall within the area of jurisdiction, did not fall within the area of jurisdiction of the does not fall within the area of jurisdiction of Commissioner of Customs Preventive West Bengal, under whom the officer concerned is working. Mr. Bose, learned advocate representing the petitioner, by drawing attention of this court to page 14 of the writ application, submits that the petitioner is owner of the goods in question, which happens to be a gold bar, now the petitioner is owner. The petitioner had purchased a gold bar from one Bansal Ornaments and such purchase is authenticated by the aforesaid tax invoice. Full stop. The petitioner is thus the owner in respect of the aforesaid goods. Full stop. By drawing attention of this court to the inventory of gold seized under section 110 of the Customs Act, under section 110 of the said Act, it is submitted that the Superintendent of Customs Preventive did not have jurisdiction to seize the said goods, inasmuch as the seizure was effected outside the area of jurisdiction of the said customs officer. Full stop. By placing reliance on the notification dated 24th of August 2017, it is submitted that in terms of the officers, it is submitted that the Government of India, Ministry of Finance within bracket Department of Revenue bracket closed within open bracket Central Board of Excise and Customs bracket closed, comma, in exercise of powers conferred, second bracket ta uthiye deben, in exercise of powers conferred under section 4 within bracket 1 of the said Act, comma, and in suppression of notification of the Government of India, comma, Ministry of Finance within bracket Department of Revenue bracket closed dated 16th September 2014 and the other relevant notifications as appearing therein had appointed officers mentioned in column 3 within bracket of table 2 of table 2. It is table 2 only. Of table 2 of the said notification to be the principal commissioner of customs or the commissioner of customs and the officers mentioned in column within bracket 4 of the table 2 thereof, comma, to be additional commissioner or joint commissioner or commissioners, additional commissioner, joint commissioners or deputy commissioners or assistant commissioners of customs, comma, for the areas mentioned in the corresponding entry in column 2 within bracket 2 of table 2. Having regard to the aforesaid, it is submitted by placing it is submitted that under table 2 serial number 10, comma, under the corresponding columns 3 and 4 bracketed moddhe dutoi, the officer is exercising jurisdiction over the areas specified under the corresponding column within bracket 2 have been identified. এবার এইখান থেকে না পেজ নাম্বার 3 লাস্টে দে থেকে একটা দে জুড়ে দিয়ে এই পুরো 4 নম্বর পাতার এন্টায়ার 3 প্যারাগ্রাফটা কপি করে দেবেন। এটাও 4 নম্বরটাও পরে কপি করে দেবেন, ঠিক আছে? এখান থেকে ওইখান থেকে পুরোটা এই দে থেকে Yes, what did you want to submit?
There are two seizures, one by the superintendent and one by the inspector of customs. There are two seizures.
ওখানে ঢুকিয়ে দেবো ঠিক আছে I'll remember same place
15 and 16.
Mr. the learned advocate কৌশিক দে তো কৌশিক ঘোষ কৌশিক কৌশিক হ্যাঁ learned advocate representing the customs authorities submits that the proceedings were initiated submits that now by placing before this court a punchnama dated 2nd February 2024 submits that the what is the name of the persons who have apprehended?
Shafiqul Mullah and Abu Khair Ghazi.
Abu Khair Ghazi and Safiqul.
Where are the names?
Lordship kindly comes to page 15 and 16.
Yes, Safiqul Mullah and
Abu Khair Ghazi.
Where is the other name?
Lordship kindly comes to page 16, point number 1. Abu Khair Ghazi. Point number 1, page 16.
Submits that Abu Khair Ghazi, ABUKHAIR Ghazi, and Safiqul Mullah were apprehended by the officers of the customs within bracket preventive on a bike bearing registration number WB26AE 4258 while they were passing through Horoa HAROA bridge at about 11:30 AM. Full stop. Intercepted বলেছি intercepted এখানে apprehend না intercepted হ্যাঁ on being so intercepted although initially the person who was riding the bike had denied of carrying any smuggled gold. However, later he tendered the gold to the officers. Full stop. Immediately the officers made him sit in the office vehicle along with the detected gold and the person concerned were brought along with the bike to the office to the register of head office
Headquarters
in the government vehicle. Full stop. Later, the aforesaid persons were further interrogated and subsequently the inventory of the goods seized were under section 110 of the said act was prepared at the office, at the customs head office at Stand Road. Mr. De submits that the goods in question, that the gold in question, goods now, gold, that the gold in question had been intercepted at Horoa Bridge within the state of West Bengal, outside the area of jurisdiction of the Principal Commissioner of Customs within bracket Port, Kolkata, and the Principal Commissioner of Customs within bracket Airport and Air Cargo Complex bracket close Kolkata.
And even the gold was tendered and was into our possession at that place.
Intercepted বলেছে কি আর পড়ে দিন লাইনটা intercepted and taken custody of. By referring to the provisions of section 110 of the said act, it is submitted that the officer concerned at Horoa Bridge, Horoa Bridge itself had reasons to believe that the goods are liable for confiscation under the said act, and for reasons as aforesaid, had intercepted the above named persons, and formalities of seizure were only completed at the office of the respondent at NS Road. Simply because, full stop here, simply because the formalities as regards seizure was completed at NS Road, the same does not presuppose, the same does not ouster the jurisdiction of the superintendent, ousted the jurisdiction of the inspector of customs or the superintendent of customs, দুটোই preventive, from preparing the seizure list. The Panchnama itself, the Panchnama was prepared at the local, this was prepared at the local. Where was this prepared?
At that place.
Panchnama was prepared at the local. Full stop. As such, there is no lack of jurisdiction on the part of the preventive officer, on the part of the inspector of customs preventive or the superintendent of customs preventive to take action, since the area of jurisdiction of the principal commissioner of customs, of the commissioner of customs under whom they work, is the whole of the state of West Bengal and Sikkim and the Union Territory of Andaman and Nicobar Islands. Wait, in submission you want to interject. Or the learned advocates appearing for the respective parties. No. It is Mr. They further submits that the petitioner till date has not made any application for provisional release. Full stop. As such, now the provisional release. Full stop. The petitioner has also failed to demonstrate by showing any credible document that the petitioner is the owner of the gold in question. The purported tax invoice relied on by the petitioner is a suspect document. I'll record. Wait, listen to me.
I made a mistake in submissions.
What?
I should correct it, Lordship, because I've taken further steps.
Panchnama?
Panchnama was prepared after the entire operation was done at office.
Very well. কোথায় আছে? হ্যাঁ লোকে করে দেবো। হ্যাঁ 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 ওরা আছে কোথায় আছে? এখানে লাস্টে থাকো, শেষে থাকো। ওটা ছেড়ে দিও, ওর পরে ওটা পরে। Suspect document. He submits that although the tax invoice indicates that the gold bar is worth rupees 150,17965.30, yet only 2 online payments, where are they?
59 and 60.
Only 2 fund transfers in support of the aforesaid transaction have been disclosed, which are at page number 59 and 60. Both are dated subsequent to the seizure of the gold in question. না আরেকবার লাইনটা in support of this course, totaling to rupees 40 lakhs. Both transactions have been had taken place subsequent to the date of seizure. In the facts noted here now, it is submitted that the present writ application has been filed as and by way of now it is submitted that the petitioner has taken a chance by filing the instant writ application. Full stop. No relief should be afforded in favor of the petitioner. Or the learned advocates appearing for the respective parties and consider the materials on record. Full stop. Admittedly, it is noticed that the seizure notice has been issued by seizure notices have been issued by the Superintendent of Customs and by the Inspector of Customs within bracket preventive দুটোই on 2nd of February 2024. Full stop. Although for 2024, full stop. However, from a perusal of the Panchnama, it would transpire that the proceedings had been initiated. Now, transpire that two persons, namely Safikul Mullah and Abu Qadir Ghazi, had been intercepted at Horua Bridge, not 24 Parganas, within the state of West Bengal. Full stop. The gold bar in question, the custody of the gold bar in question was taken at the Horua Bridge within the state of West Bengal. Full stop. Though the seizure thereof, though the formalities in connection with seizure thereof appears to have been concluded at the headquarters of the petitioner. Although Mr. Bose, learned advocate, by placing reliance on the judgment delivered by this court in the case of Bangari Bhola versus Union of India and others, unreported judgment delivered in the case of in WPO 334 of 2024 on 7th of May 2024 submits that since the seizure notice, seizure notice has been issued by the customs officer within bracket preventive within the area of jurisdiction of the principal commissioner of customs within bracket Port Kolkata, the proceedings are without jurisdiction. I am afraid. Now, I find that in the said judgment, I find that the said judgment is distinguishable on facts. In the said case, the goods in question were intercepted and a detention order was issued within the domestic terminal of the airport, unlike the present case, where unlike the present case, unlike the present case, full stop. In the present case, full stop. There is another very important aspect of the, unlike the present case, having regard thereto, simply because the proceedings which were initiated, simply because, simply because bolechi, having regard to the aforesaid, it may be noticed. No, having regard, it may however be noticed that the proceedings under section 110 of the said act on the basis of it may be noted that the proper officer, it may be noted that the customs officer had reasons to believe that the goods are liable to for confiscation. Proper officer in the instant case, the officers under the principal commissioner of customs, officers under the commissioner of customs within bracket preventive West Bengal had reasons to believe that the goods in the instant case, the goods not, that the gold in question is liable to be seized liable to be seized, no, liable for confiscation, liable to confiscation, and had accordingly set up a plan to intercept the gold at Horoa Bridge. Full stop. The persons named herein above, namely, the persons named herein above, persons name noy, duto naam ache na. Accordingly, Safikul Molla and Abu Khair Ghazi were intercepted at Horoa Bridge, 24 Parganas North, within the area of jurisdiction of the officers under the Commissioner of Customs within bracket preventive, West Bengal. The gold was also taken custody of at the said location, and only the formalities in connection with the seizure were completed at the office, at the head office of the respondents. Full stop. The matter has travelled further. A memorandum of arrest has also been issued, and on the basis thereof, they have got bail.
Yes.
A criminal proceedings had been initiated, and ultimately by an order dated 3rd February 2024, the detainees were granted bail by the office, by the court of the Chief Metropolitan Magistrate, Calcutta, granted bail, granted bail. Admittedly, in this case, it may be noticed that the petitioner has chosen not to make any application under section 110 within 110 capital A of the said act for provisional release of the gold full stop. The failure on the part of the petitioner to make such an application, along with the purported tax invoice, creates more than an element of suspicion as regards the ownership of the petitioner in respect of the gold in question. However, without going into such issue, at this stage, I am of the view that there is no jurisdictional error. There is no, I am of the view that the order of seizure passed by the inspector within bracket preventive and the superintendent of custom within bracket preventive do not suffer from any jurisdictional error. the application fails and is accordingly dismissed, there shall be no order as to cost.
Grateful to you, Lord.
ওই ওখানে না এটা বলেছে না আর দি লোকেল ওখানটাকে লাল করে দিও লোকেলটা হ্যাঁ ব্যাস লাল করে দিও থ্যাংক ইউ
Grateful to your lordship.